Memos you can give it. Hearing. This case was posted for right for local government. Insurance company is intentionally dragging the opinion. It is case and court case for enhancement also. Today it was mistake, it was not posted for Monday. You ready to argue on Monday? Please, brother. Application for release of the amount is also quite matter. Even that order passed by this amount was not completed by the insurance company. That is one case. Release of amount. 50% deposit amount was not completed by the insurance company. Don't file execution. Please, brother. And in one case, they have deposited. I have filed application for release of that. All the respondents are senior citizens. All. Please, Monday. Monday. Which year matter? 2020.
Attendance page wise. Page number 9, serial number 47 to 49. Page 10, serial number 50 to 56.
56, sir.
56
Request of the council for urban relist next week. Registry to secure trial court records.
Page number 11, 57 to 65.
What do you want in this? 59? Huh? Now, who are you? Respondent number? So you want time? The motion matter for adjournment, call for TCR.
Page 12, syllabus 66 to 69.
Who are you? Council for the appellant seeks time to relist after 2 weeks. Settled out of court. So you want to withdraw? Huh? Dismiss for what? Dismiss and on merits you want me to dismiss or what? Memo on that. Then counsel for the appellant is present. Sitaramaya idara. Then counsel for the appellant files a memo stating that the matter has been settled out of court. Hence, this appeal is dismissed as having become infructuous in view of the memo submitted by the appellant. Yes.
Page 13, syllabus 70 to 74.
Registry to file. List MFAs also.
643
Along with this appeal.
Page 14, syllabus 75 to 80. 75.
What do you want? Your fault? At request of appellant, release this matter next week.
Number 77.
R2.
You are You are appellant.
and responding.
You are which respondent?
Both responding.
You are fourth respondent. So you are reporting the death of R2. When he died.
Month back.
Bennett, counsel for the respondent number 4 reports the death of respondent number 2. Appellant to take necessary steps. Relist up to 2 weeks. Yes. Monday. 51. What do you want? Records are required. Serial number 51 at request of both learned counsel relist next week. In the meanwhile, registry to secure the trial court records.
For orders. Still number 1, Dinesh P. Balare.
The KSRTC Chikmagaluru, Vakalat says Bangalore. New Yes, what is the correct one? As per the circular of KSRTC. Division.
Bangalore.
Your head office is at Bangalore only. Head office is Bangalore, and you have been given, which is that circular? The Vakalat filed by the respondent KSRTC. The head office Bangalore, signed by the law officer, is accepted. Yes, notice of vacant. Notices to go. No, other than insurance company. Agila. R1 year. R2.
Only one respondent.
Only one respondent. List for admission. Where is Shankar Gaud? Okay. List next week.
Still number 2. KG.
Siddhalinga Gowda. Process fee to issue notice to R2, week's time granted to do the needful dispensation. Notice to respondent number 1 is dispensed in view of the insurance company admitting the liability.
Bill number 3, Ashok and Patil.
General counsel for the appellant files a memo to treat respondents 1, 2, 4, and 5 as LRs of deceased R2. Same is accepted. Counsel for the appellant to carry out the corrections and carry out the amendment in the first title. So copy of the appeal memo on the other side.
Number 4, Pradeep.
Week's time granted to comply.
Bill number 5,
Same. Already. Already. Equal or not?
6. Bill number 6,
No, relevant counsel submits, he would do the needful during course of the day, same as an order issue notice.
Bill number 7, Miscellaneous.
This to R4. Insufficient address, week's time granted. If needful done, issue notice to R4.
Bill number 8, Haveri SS.
There 7 ಅಲ್ಲಿ Mr. Janardhan Reddy ಅಲ್ಲ ನೀವು? ಯಾವುದು vacating stay, there is some objection. Who has filed the vacating stay? Other side ನೀವೇ ಹಾಕಿರ್ಬೇಕು ಇಲ್ವಾ? Ilva, then that must be filed by the. All right. In the meanwhile, compliance also to be carried in.
8, Haveri SS.
Respondent number 3, the
Respondent number 3.
issue
Is
court
insurance
notice to R3.
This is insurance.
ಯಾರು?
Ishko Toki. There are.
Keshav Prasad was appearing for IFCO token. R3 IFCO token.
After.
ಯಾರು? B Pradeep appears.
Pradeep, Rachel Lingraj.
BC Shivannagowda. General counsel BC Shivannagowda to take notice for respondent number 3, registry to show his name in the cost list.
Bill number 9, Gowda.
Dispensation of R1.
Council files a memo seeking dispensation of notice to R1 as liabilities admitted by R2. Same is accepted, notice to R1 dispensed.
10, Krishna Pujari.
One matter to be referred to Lok Adalat. Liability is not disputed. Your claimant. Notice to R1 and 2 is dispensed in view of liability having been admitted by the insurance company. Matters referred to the Lok Adalat for resolution of the dispute.
Level 11.
Literal law. Or same order in this case.
12.
Notice to R1 dispense in view of liability admitted. Matters referred to local.
12.
But I am for appellant, but a notice to R1 may kindly be dispensed and R2 ICICI insurance company served my lord. Any panel advocate, if director take notice, I will serve the court.
Yes, notice to R1 dispense in view of liability admitted.
Admitted.
Admitted in view of liability admitted by the R2 insurance company. Learned counsel Shri Ashok Patil. M. N. Ashok N. Patil. The director will take notice for R2 registry to show his name in the cost list.
Well, may I make one submission? A very short difference that is instead of taking 12,500, 10,000 is considered. So if my lord posts the matter to next week, my lord, it may be disposed of in one shot. Next
Alright.
week.
Ashok Patil has to inform, they have to give him a color.
Yes.
File on ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ.
Correct, sir. Sorry.
I will list it after 2 weeks.
Yes.
Ready and because he also needs instructions from us. Relist after 2 weeks.
13. Vishwanath Pujari.
Same order. Okay. Notice to R1 dispense as liability admitted. Matters report to Lok Adalat. Delay ಇದೆಯಾ? R1. R2 served, ಅಲ್ಲ? We'll condone the delay. A1, orders on A1 of 21. Delay of 81 days. I peruse the affidavit annexed to the application, being satisfied with the reasons assigned and partial. Delay of 81 days is condoned. IA is allowed. Yes.
14.
We'll refer it to Lok Adalat.
Serial number 14. Devamma MC.
Weeks time granted to do the needful.
15. Shilpa Shastri.
Shastri, you're muted. Mute.
Sorry, my lord. Notice to R1 and R2 may kindly be dispensed and I filed an IA for return of TCR. TCR may kindly send back to the tribunal at least order sheet and wakalat.
United India Insurance. Who appears for United India Insurance? Mr. Janardhan Reddy. Registry should show the name of Learned Counsel Sri Janardhan Reddy for R3 and delete the name of Learned Counsel Ashok N. Patil from the cost list. Notice to R1 and 2 is dispensed as liabilities admitted by R3. Counsel for the appellant has filed seeking IA number 1 of 23 to return the TCR. The trial court. You want to
Return to the trial court, my lord.
or what for withdrawal?
Withdrawal of the amount deposited by the insurance.
All of the amount deposited by the insurance company before this court. ನಿಮ್ಮ appeal ಅಲ್ಲಿ ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ ಇಲ್ಲಿ?
ಹೌದು ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ they are satisfied the award. I filed the IA appeal for enhancement only.
ಏನ್ ಬರ್ದು?
IA 1 of 2023 to return the trial court records to the trial court for withdrawal of the amount deposited by the insurance company before this court.
Not before this court.
Before trial.
Full stop. Immediately thereafter, the record shall be transmitted back to this court. Yes.
My lord, may I make one submission? My lord, actually, as far as claimant's appeal is concerned, madam, we are facing the difficulty in only two aspects. One is IA for return of LCR, and second one is IA for permitted to withdraw. These IAs is very urgent. We are in urgency in all the cases. My lord, in this case, for example, I filed the IA on 17/6/2023. And now it is posted after 6 months. That is why my humble request is, if my lord issue any instruction to the pending branch just to post all the, because hundreds of IA is still pending without posting the IA. This is only one sentence order, but the this cause is effect is very deep. That is why I am requesting my lord, humble request, just to send a message to the pending branch. Post all the IAs wherever the IA for return of LCR and permitted to withdraw, IA for permitted to withdraw is pending. That is the only my humble request.
Yes, I've noted. I will issue the instructions today itself.
Okay.
Yes. Next.
16, Sachin BS.
Just remind.
Sachin BS.
ಯಾರಿಗೆ ಸರ್ವ್ ಆಗಿದೆಯಾ ಡೆಲಿವರ್ಡ್
Sufficient ಅಂತ ಇಲ್ವಾ?
ಐಟಮ್ ಡೆಲಿವರ್ಡ್ ಅಂದ್ರೆ ಇನ್ಸಫಿಷಿಯಂಟ್ ಡ್ರೆಸ್ ಆಗ್ತದೆ. Item delivered on ಯಾವಾಗ ಅದು insufficient date
28/8/23.
28/8/23 insufficient address ಇದೆ. Before that 22/11/22 you are showing this item delivered.
ಉದ್ಯೋಗ ಕಾರಣ insufficient. ಯಾರೆಂದು ತಿಳಿಯದ ಕಾರಣ. We don't know.
2 times it is item delivery confirmed ಅಂತ ಇದೆ ಇಲ್ಲಿ.
Son of late Lingappa. Insufficient door lock.
Item delivered on 30th August 23. ಅದು ಯಾವಾಗ insufficient ಆಗಿದೆ?
Insufficient address 28/8/23.
ಆಗಿದೆಯಲ್ಲ.
2 times.
R1 is who's the R1? You are owner. Who was the counsel who appeared before the trial court? Trial court records are not on our ಒಂದು ಕಳಿಸ್ಬಿಡಿ. Trial court records ಇದೆಯಾ? Just check the trial court records and serve one notice to the council also. I will treat this as sufficient. Okay. The council for the appellant files a postal tracking system report of the notice having been delivered to respondent number 1 on 30th August 2023. Same is accepted. Meanwhile, learned counsel may also serve a copy of the appeal to the learned counsel who represented the the respondent number 1 before the tribunal. We'll stop. Next, IA number 1 of 2023 is not pressed by the appellant, correct? All right, await trial court reports. Only the trial court. Wait. Entry moderate, yeah? Entry moderate extended to next. Yes.
Number 17.
Ah. Dispensation. Notice to R1 is dispensed as liability is admitted by R2. Deposited. Oh. Release next week for a day.
Number 18.
Week's time granted.
Number 19.
You don't need to do the needful. Week's time granted to do the needful. What about withdrawal of the amount?
As of the date of, there was no policy. Another 3 connected cases yesterday after the document. So, after subsequent of service on the
R1 is a claimant. He was not having the policy. So even if you accept your version and allow your appeal. No, if I accept and allow your appeal, what would be the outcome?
The owner has to pay the compensation.
You already paid, you can recover.
No, there is no policy, there is no breach of consent. In case any violation, the policy was issued. There is no policy as of the date of action.
So it is not pay and recover also.
Yes.
All right. Relist this matter. What is this delay?
Delay in paying the appeal.
Notice yaar go bekivaga.
The second respondent.
Who's R2?
Army is the owner.
A week's time granted to the needful for R2. Yes.
20. Shashidhara.
Petition number 1 is the only legal error, legal error. Petition number 2 for the tribunal is not made as part of the system.
Seven 523. Who's petitioner number 2? Borappa. Yeah, she's the wife. Appellant is the wife. No issue. Only son. No other issues are there. The note below the first title of the appeal memo is accepted. The appellant is the only legal heir of the deceased. Legal heir of the second claimant before the tribunal. Therefore, office objections is overruled. You are seeking dispensation to one. They are owners. Liability is admitted.
3 and 5 are liable.
3 and 5 are.
Interest of this. 3 is the ICICI general.
So 1, 2, and 4. Notice to respondents 1, 2, and 4 is dispensed in view of the liability having been admitted by respondent number 3 and 5, the insurance company. Issue notice to respondents 3 and 5. Non-taking of steps. 3 weeks time is granted to take the necessary steps. Yavaga 22, 3.
321.
ಅದರಾದ್ಮೇಲೆ ಏನು ತಗೊಂಡಿಲ್ಲ ಅದು. ಅದಾದ್ಮೇಲೆ
So reporting ಆಗ್ತದೆ. ಅದಾದ್ಮೇಲೆ ಬಂದಿಲ್ಲ. ಇಲ್ಲ. Dispose of the
Taking judgment.
ಮಾಡ್ತಾರೆ.
We've seen that the respondent number 3 passed away in view of the postal shara dated 22/3/21.
Reporting death ಹಾಕಿದ್ರು.
Postal shara is 22/3 or death is 22?
Death, reporting death memo ಹಾಕಿದ್ರು.
In view of the memo filed reporting the death as 22/3/2021, till date, no steps are taken to bring the LRs of R3 on record. Hence, appeal against R3 abates.
22.
Admitted on 29/6/2016. Now the first occurrence is that I filed these 3 applications. We have record the last. Regarding 245, therefore police is trying to take steps. The second matter. Second, 245. Therefore police is trying to take further steps.
2 weeks time granted to take necessary steps for respondents 2, 4, and 5.
Now, here, IAS 103 for the same purpose. There's a mistake in line number 1, the number of record data. Therefore, I tried one more IA, then line number 3. Line number 2 to set aside the weight. All these IAS may be wrong.
All these IAs.
IAS may be wrong for the current is the first occurrence.
So in both the cases, appellant, they are appellant, first appellant. Good. Heard learned counsel.
The cases 1 and 3 are same.
Huh?
1 and 3 IAs are same.
ಯಾವ್ದ್ರಲ್ಲಿ?
Bringing illness in both
First and
the cases.
second. 1 and 3 IA.
For bringing illness ಅಂತ. So ಒಂದು IA ಹಾಕಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಇನ್ನೊಂದು IA ಸೇಮ್ ಕ್ರಿಯೇಟ್.
So you will not press IA number 1 in both the matters?
Yes, there's a mistake in paying.
That is a repetition, Allah. So I'll dismiss IA number 1 in both cases as not pressed. IA number 1 of 2022 is stated, the learned counsel for IA number, the learned counsel for the appellant does not press IA number 1 of 2022 in both the matters. I've heard learned counsel for the appellant on IA number 2 and 3, which is filed to bring the LRs of appellant number 1 in the form of appellant 1A to C. No delay, Allah?
That is not even.
And also to set aside the abatement. The applications are filed on time. Full stop. Being satisfied with the reasons assigned and cause shown, the applications are allowed. Appellant number 1A to 1C shall be brought on records as LRs of appellant number 1. Abatement, if any, is set aside. Then a counsel for the appellant to carry out the necessary amendment, file the amended cost title by serving copy on the other side.
That's why it's called.
Okay, copy ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು after you carry out the amendment.
Right now, the matter is going to be settled within the party. All it up on this.
Money recovery. 2 weeks. Real list after 2 weeks.
23. Permission.
Notice to R6 is returned with the postal shara as refused. Same is held to be sufficient. What about 4, 8 and 9? Huh? Again comply ಮಾಡ್ತೀರಾ? Not taking up steps. Memo filed by cause of. How many appellants are there?
ಏನು ಹಾಕಿದ್ದಾರೆ ಏನು ಬೇಕಾಗಿಲ್ಲ.
A number 1 to bring the loss of the appellant is filed. A week's time is granted to comply with the objections raised by registry. Sole appellant is dead. 1 week granted. Same in both the cases.
24. N. Suresha.
Dismissal of appeal as against unserved R2434N. Okay.
Not taking steps.
What PS, where is Suresha?
N. Suresha.
There's no representation on behalf of the appellant. So also the respondents, we'll list next week. Provide one opportunity to the appellant.
25. Is that
Yes. What's up with the complaint now?
Council submits that he would comply with the objections within 2 days. We'll list next week. Okay, so ಯಾರಿಗೆ? So respondent number 1 is no more now.
Yes, no.
So rank of proposed LRs to be mentioned.
The first of the day, I will serve the customers.
So you have not filed wakalat yet.
There was no order from the court.
Now, whether the application is allowed or not allowed.
Not allowed. Let them comply.
Let them first comply. After you come on record, then you file wakalat.
2 days.
2 days time granted, relist next week.
hearing on IAS number 26? Karita HC.
Calling order. Delay of 957 days in filing appeal. Huh? Can't hear you. The claimant's appeal, is it? Not interested in going on with the matter. Huh? T23 June it is dismissed. 4 times time is granted to you. You don't want to comply. What are the office objections? ಜೋರಾಗಿ ಮಾತಾಡ್ರಿ ಅಲ್ಲಿ ಕಾರಿಡಾರ್ ಅಲ್ಲಿ ಕಿರ್ಚ್ಕೊಂಡು ಹೋಗ್ತೀರಾ You're an youngster. Be brave and bold. Only then you'll get courage and confidence. Delay allappa. Delay. Other than delay, there is some objections. Apart from the delay, there is some objections which you have not complied. Hmm?
Three office objection.
Date of execution and place to be stated. Court fee ne kottilla ನೀವು? May not paid court fee, date of execution and place to be stated in the vakalat. 7 days in filing the appeal. What are the injuries suffered? What happened to the claim petition? What are the injuries suffered and what is the order passed? Huh? There is counsel for the appellant. And IA number 1-2 of 2023 to recall the order dated 12/6/2023, whereby this court dismissed the appeal for non-prosecution. As objections were not complied with. I have produced the affidavit annexed to the memorandum of facts. There is the memorandum of facts filed along with the application, being satisfied with the reasons assigned therein. Deem it appropriate to allow the application, accordingly application is allowed. The appeal is restored to its original file, subject to payment of cost of rupees 2,500 to the advocate's library fund within a period of 2 weeks from today, within which period the compliance shall be met with by the appellant. Failing which, this order would not inure to the benefit of the appellant. 2 weeks' time, if you don't pay the cost and don't comply, it will automatically get dismissed again.
Number 27. Suresh A.
Substitute. Notice yesterday. Yesterday your notice ಹೋಗಿತ್ತು. Notice yesterday ಹೋಗಿತ್ತಮ್ಮ registered post ಅಲ್ಲಿ. How many times, madam, you have taken? 2 times. Counsel for the appellant has filed IA number 2 of 2023 to take out notice to respondent number 2 by way of substituted service through newspaper publication in Kannada Prabha. Produce the affidavit annexed to the application. Deem it appropriate to allow the application for proper service of notice to R2 accordingly IA number 2 of 2023 is allowed. The appellant shall take out notice to R2 by way of substitute service through newspaper publication in Kannada Prabha, daily newspaper rather. Kannada Prabha daily newspaper of Tumkur edition, which shall be published on or before
19th January 2024, as doing instead of hearing as 5th February. Number 28.
day of 508 days in filing.
So during this duration, there were a lot of days.
Lot of
Days lost.
talks.
Lost.
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 Hmm.
And by the time it reached and referred to the 508 days. That's it. The road for the appeal had been, the application of appeal was dismissed.
Your claimant
And the claimants.
on it will issue notice. Issue notice to the respondents.
29.
Fresh matter. Issue notice to respond.
30.
Damages. Notice has to go. Issue notice to respond.
31. MH.
Issue notice.
32. Uday Prasad KG.
Issue notice to respond.
33. R. Shashindhara.
Same order. Admitted liability. Notice to respondent 1 and 2 is dispensed. In view of the liability admitted by respondent number 3. Issue notice to R3.
34.
Yes. Accidentally, liability has been fixed on the ground that he is not having a very real apparently vehicle in question for HGV Narinala. He is having a real to PSV bus and LM. Liability has been fixed on the owner. Owner and the driver is filed appeal, directed appeal. I filed appeal for harassment. Here recovery order, there is a delay for 2,533 days in filing day. And file application, immediately.
You want to file objections?
Apex court has categorically, will not come in the way.
All right, he wants to file objection, let him file.
Just taken time. Take the.
Yeah, how you'll file next week?
Next, 16th.
So already your appeal is there in 2014.
Recently, I filed.
No, you are appearing for insurance.
Insurance company, it's not a law. It's paying for insurance. Owner and deposited the amount here.
No, the other appeal 34.1 is filed by whom?
Owner and driver.
Owner and driver.
And award has been passed 9,78,000. They have deposited the amount here, 9,78,000 plus 25,000 here.
Owner and driver is filed the other appeal. You are the claimant.
I am claiming.
You are the insurance company.
And he is the insurance company.
Right, so at the most, he will not be entitled for the delay period. No, is there any judgment which says that beyond the 2,500 days, the delay should not be condoned? He will not be entitled for the interest for the delayed period. Learned counsel for the appellant and respondent are present. Counsel for the respondent insurance company seeks time. Yes.
He is appealing for owner. Yes.
Copy on Kodio.
14.
Council for R2 seeks time to file objections to IA number 1. Same is granted, released next week. Copy of the appeal is served to R1. Yes.
45.
Next week, Bharat, listing it. Relist on 16th.
35. Bella Shankar.
Issue notice to respond.
36.
Same. 37, 38 also. Shantaraj,
38.
Gurudev,
Shantaraj.
37. Issue notice to respond. Shantaraj,
39.
38 also. Same. ಯಾವುದು 39? 39, 40, 41, 42. Issue notice.
43.
43, Irappa Reddy. Appellant number 3 is dead. E3 and E4. You filed IA to bring them on record, LRs on record. Objections ಏನಿಲ್ಲ. Yes, who appears? Kantaraj, respondent. Notice ಹೋಗಿಲ್ಲ ಇದರಲ್ಲಿ?
Appellant.
ಇಲ್ಲ ಇಲ್ಲ. Otherwise notice is not come. Unless his name is shown. Sir,
Kantaraj.
ಇಲ್ಲಿ ಬೋರ್ಡ್ ಮಾಡಿಲ್ಲ, ಪಾರ್ಟಿನ
Advocate. There is only one respondent. He is appearing for this.
For A3, there is a delay. For A4, no delay.
A4.
The counsel for the appellant filed 3 applications to bring the LRs of appellant number 3 on record and 3 applications to bring the LRs of appellant number 4 on record. Full stop. IA number 1, 2, and 3 of 2023 is filed to bring the LRs of appellant number A3, whereas IA number 4, 5, and 6 is filed to bring the LRs of appellant number 4 on record. I perused the affidavits annexed to the application. Being satisfied with the reasons assigned and the cause shown therein, this court deems it appropriate to allow both all the applications to bring the LRs on record and to condone the delay of 467 days in filing the application to bring the LRs of A3, appellant number 3 on record. Accordingly, the applications are allowed. Delay of 467 days is condoned in filing the LR application for A3. Abatement is set aside. There is no delay in filing the LR application to bring the LRs of A4 on record. Therefore, IAs 1, 2, 6 are allowed. Delay is condoned, abatement is set aside. Appellant shall carry out the amendment to incorporate the name of appellants. Number 8, LRs of the appellants in the form of 8.3, A to E, A to E for the LRs of appellant as LRs of appellant 8.3, and for A4, A to B, A and B, A and B as LRs of appellant 4 on record. File the amended cost title and serve copy of the same on the council corresponding.
44, P. Narayanappa.
Additional documents. A2 for 16 TI and stay. Your appellant, you are seeking time. ಏನಪ್ಪ ಏನ್ ಹೇಳ್ತಾ ಹೇಳಿ
Senior not well.
senior not well 2 weeks time already 2016 8 years have gone by. I can't wait for your senior. Huh?
Next week.
What is this case? You also don't know. What is this case? What is the appeal about? Declaration and injunction. Mike and nim kade ಮಾಡ್ಕೊಳ್ರಿ. Mike and nim kade ಮಾಡ್ಕೊಳ್ರಿ. Don't behave like uneducated. You're a lawyer. You can speak on the mic is provided for you. Be louder. Otherwise, leave the mic and have the strength to speak louder. What is this case? Please, you can sit and read what is the judgment of the trial court, what is the appellate court judgment. Question of law. ಯಾವಾಗ ನೀವು ಕಲಿಯೋದು ಸೀನಿಯರ್ ಅಲ್ಲೇ ಇರ್ತಾರೆ ನೀವು ಕೂತ್ಕೊಂಡು ಓದಬಾರ್ದೇನು how many years you are practicing at least you should know what is the judgment, whether you are who are you, defendant or plaintiff? Plaintiff in the trial court ನೀವು ಯಾರು ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಕರೆಕ್ಟ್ plaintiff trial court ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ನೋಡಿಲ್ಲ ಫೈಲ್ ಕೂತ್ಕೊಂಡು ನೋಡ್ಬೇಕು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸುಮ್ಮನೆ ಬಂದು ಕೂತ್ಕೊಂಡು ಅಲ್ಲಿ ಇಲ್ಲಿ ಓಡಾಡೋದಲ್ಲ. Counsel for the appellant and respondent seek time release next week. Don't ask time next week. Argue the matter whether you or your senior. We can't keep old matters pending.
45, CH-16.
The respondent of one passed away. It was listed for admission. At that point of time, we came to know that the respondent of one passed away.
Notice is gone.
Notice has not been murdered, even on the appeal also.
Issue notice on IA and the main.
Please.
6, Mariappa.
ಏನ್ರಿ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ರೆ ಏನ್ ಬೇಕು ಜೋರಾಗಿ ಹೇಳ್ರಿ. 46 ನಿಮ್ನೆ ಕೇಳ್ತಾ ಇದ್ರೆ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ. 46 ಹಾ what is this appointment of guardian? No representation on behalf of appellant. Counsel for respondent is present. Release next week.
Number 47. Purple CM.
Owners bill, filing the liability. The trial court has postponed the liability on the order.
You are ready, madam?
Okay.
Senior is going to argue. Senior is going to argue or you are going to argue? Why? You are practicing for more than 5 to 10 years, I think. Illa. ಎಷ್ಟು ವರ್ಷ ನಿಮ್ದು ಪ್ರಾಕ್ಟೀಸ್? ಸಾಕಲ್ಲ MVC ಕೇಸ್.
Amount is deposited.
No, you are claimant.
No, I am the owner of the. Owner, sir, amount is
ಅವ್ರು
deposited.
ಬರ್ತಾರ ನಿಮ್ ಸೀನಿಯರ್ ಪಾಸ್ ಓವರ್ ಮಾಡೋದು. ಪಾಸ್ ಓವರ್.
48, they reached 60.
ಜಗದೀಶ್. ಡೆತ್ ಕೇಸ್. Dismissed. What ground? Ten days delay in filing FIR. No, but you must have gone to the hospital. Where he died? Where? On the spot. He must have gone to the hospital or not? So no medical records to show. The delay in filing, how many days? Insurance ilva. Owner mela. So, Girish B. Baladare. He appears for. Insurance was not made a party. You need trial court records. So these three to secure trial court records. Go and do some homework and find out if there is a delay in filing FIR, whether on that ground claim petition can be dismissed. Number 8 innocent.
3435
Registry to list MFA 3435 of 20 along with this appeal. Release next week. Huh? Ravish. Yes. Accident is on 13 to 18.
Left forearm injury with both bones fracture.
Left forearm injury with both bones fractured, radius and ultra. Forearm.
Pain suffering is another type of. In pain suffering is another type.
Pain and suffering, Allah. 40,000.
Doctors advise for 1 year bed rest.
1 year bed rest. Left forearm injury, both bones fracture, 1 year. What is there for 1 year bed rest? What is the age of the patient?
35 years.
All right. What is your grievance in what is lacking in the compensation?
Income was taken 9,000. The accident is of the year 2018. I mean, it has to count for 12.5.
Have you produced any proof of income?
No.
What was the avocation?
Tailoring.
Tailoring. But no documents produced.
No documents.
Only self-serving statement.
Yes.
So income is taken by the tribunal at rupees.
9,000. 1,500.
Only the which paragraph?
Page number 8 of the number, paragraph 8.
The MACT has taken 9,000.
Yes, ma'am.
What is the chart?
12,500 for the 2008.
All right. What is the age?
35 years.
Any dispute? Ravish? Age. What is the multiplication?
16.
16, huh?
16.
16. Oh, 35. Yes. ಅಷ್ಟೇನಾ? Loss of amenities ಕೊಟ್ಟಿಲ್ಲ. Loss of income during treatment. Medical expenses is correct? Actual. Future medical expenses? The doctor has stated 25. Loss of earning during treatment, 900.
9,000. 6 months.
900 ಕೊಟ್ಟಿದ್ದಾರೆ.
Treatment 900.
Ah.
Later period 4 months.
Treatment, loss of earning during treatment is 900. Loss of bed rest is 36,000 at 9,000 per month. Just thing like put it 4 months. So that will have to go up because of the income increase. But the doctor says 1 year.
1 year doctor has said.
He was working as a tailor.
Tailor.
Yes, that's all. Yes, sir.
After doing the latest treatment, after the latest altogether is working. 4 months to be taken.
4 months.
900,000. After, it is altogether. After doing the latest means including treatment.
Including the?
Including treatment, under 50,000 minus 36.
You mean to say you calculated 12,500?
12,500 into 4 comes to 50,000.
Correct.
Minus 36,000.
Minus?
Plus the 9,000, including plus.
No. Mr. Ravish, the loss of income during later period is because he is laid up in the hospital. He could not earn his income.
Treatment period means later period.
Correct, sir. That is treatment and later period is correct. How minus 46 and it will be minus 36,900.
9,000 should be included in that. Because the treatment period.
How 9,000? Which 9,000?
Only during the treatment period, not a lot of during later period.
That's 900.
900. 3,300.
900 alva?
Yes, ma'am.
Not 9,000 alva.
900.
So it is 36,900 minus 36,900.
800 means
But it is not including treatment period. Treatment period is for 4 days. It will come to 1,664, like 4 days month. 32 is the, he has admitted to hospital 13 month.
Hmm.
Is admitted month. Discharge date is 16 to 8.
How many days he was inpatient? 4 days.
4 days.
3,000 minus 36,900.
What is the meaning of loss of earning during treatment? What is the meaning of that?
But 4 days he was treated, he was discharged. After 15 he was discharged.
Hmm.
And doctor has advised to 1 year bed rest.
Now we'll come to that. Now we are on the loss of income. You said 12,500 into 4 months. So now the treatment period also gets merged with that. The food, nourishment, attendance charges is separately awarded to you at 10,000. Yes.
But loss of future earning is 12,500 into 10.3, 22,46,900 minus 1,78,490.
500 into 12 into 10.3 is a disability.
10.3.
Disability. Appointed by the doctor.
30% limb disability. 1/3 is taken. 1/3 is the.
Where is that? Which paragraph?
20.
Para 20, evidence of PW2 shows petitioners having 31% permanent disability to left lower limb. Disability to be done, whole body ಹೇಳಿಲ್ವಾ ಅವರು? Doctor has not stated.
No, doctor has not stated.
So it becomes 10.33. So 12,500 into 12 into 10.33. Into 16.
16.
That's right.
2,47,920.
1,78,480.
This will be the disability during for future earning capacity. Yes, next.
Conveyance nourishment another 10,000.
Conveyance.
Conveyance nourishment attending charges 10,000 is the lowest.
25,000 ಆಗಲ್ಲ.
Due to
All right.
then amenities ಕೊಟ್ಟಿಲ್ಲ others.
Amenities only 10,000. What, sir?
No.
Even according to the table,
20,000.
25,000 rupees amenity should be free. Amenity. That's all.
But as per doctor advice, 1 year.
Where is that?
But
Records idea.
Stage of
Where is that? No, I'm failing to understand. If there's a fracture to the forearm, how there will be 1 year?
For example, belly guru or belly super. One of the
3 months.
members of Kaila can understand. Only LL work and not done. Doesn't make different going.
Whether he is the doctor who was treated.
I want to be just a reason. Definitely discuss ಮಾಡಿದ್ರೆ
ಕೊಡಿ. Did you cross-examine the doctor?
No,
Madilva?
Yes, cross. Deposition not.
No, there cannot be 1 year disability, bed rest. But have you,
Numerous home.
but have you cross-examined? But good, that's all. Right on. Layman. Date of accident is 13/2/2018. Claims to have worked as a tailor, earning 15,000 per month. No documentary proof placed on record. Tribunal has taken the income to be 9,000 per month. The notional chart of Legal Services Authority describes 12,500 for the accident year 2018. Hence 12,500 is taken as income of the claimant. Claimant is age 35 years. The appropriate multiplier would be 16, which is rightly taken by the tribunal, which does not call for interference. PW2 doctor has been examined. He has assessed the disability to be 31% to the left lower limb. But however, has not disclosed the functional disability to the whole body. Tribunal has taken the disability to whole body at 10.33 by dividing 1/3 to the whole body. The loss of future earning capacity due to the injuries would be 12,500 into 12 into 16 to 10.33%. Which would be 2,47,920 as against 1,78,496. Full stop. Next paragraph. Towards injury, pain and suffering, medical expenses, future medical expenses. No interference is called for, same is retained. Towards loss of earning. During later period, in view of this quote, enhancing the income from 9,000 to 12,500. Same shall be taken for a period of 5 months. 12,500 into 5 would be 62,500. Tribunal is awarded 36,900. Hence, directing the same 25,600 in addition requires to be awarded under this head. Towards food, conveyance, nourishment, and attendant charges, tribunal is awarded 10,000. I deem it appropriate to award 25,000 under this head. Tribunal has not awarded any amount towards loss of amenities. 25,000 rupees is required to be awarded, is awarded under this head. Full stop. In view of the above, claimant is entitled to total compensation of dash. Full stop. Appeal is allowed in part. Claimant is entitled to total compensation of dash at 6% per annum. All other terms and conditions stipulated by the tribunal stands intact. The balance compensation, enhanced compensation amount shall be paid within a period of 4 weeks from the date of receipt of copy of the order. Paper ಮಾಡಬೇಕು ಅಂದ್ರೆ ನೀವು ಒಂದು ಕೈಲಲ್ಲಿ ಹಾಕಿ ಇಲ್ಲಾಂದ್ರೆ ಅದು gets lost.
ನಿನ್ನೆ ಅವ್ರು ಹಾಕಿದ್ರು additional. Okay.
Bill number 51 adjourned. 52, Sanat Kumar K.
Sanat Kumar. ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. There's no representation on behalf of appellant. Counsel for respondent number 2 is present. This is an appeal by whom? Your owner ka? For insurance company. Sanat Kumar. Released next week. Copies to be furnished to learned counsel for R2. Prakash MH. Sampati, you are ready, Ravi? ಅವ್ರು ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ ಅವರು ಇನ್ನೇನೋ ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತಾರೆ, ನೀವೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ರೆ ಅವ್ರೇನ್ ಹೇಳ್ಬೇಕು. ಎಸ್ Hegde, you have to mute it and you are disturbing the court. Ramachandra is the deceased. Died on?
Age of the deceased is 32 years.
Wife and minor children.
Wife and minor children.
Mother. Age?
32 years.
Avocation proof of income?
Lordship, we have produced RTC, so starting in this was this part, even he expired, but still it is in his name. The title is not considered that the name is not in the deceased name, so they are taking notional income for their.
How much is taken by the tribunal?
12,000.
How much should be?
P14 we produced.
How much should be taken? How much should be taken?
Lordship, we are losing 30,000 because we have not produced any of the.
So if you say he's earning 30,000, it should be accepted. So notional income of 12,000 is taken.
Accident is clear 2008.
Okay, next.
Paragraph 18 of the judgment, the deceased mother is given an application stating that they were going with Ravi, Hospital and President.
What is the multiplier?
16.
Correctly applied? What about what's next?
Prospects, social
Future prospect is given. ಏನ್ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ ನಿಮಗೆ? Consortium 40,000 is given. How much should be given? The loss of consortium 40,000, parental consortium 1,20,000, filial consortium 40. So totally 180, 2 lakhs is given. How many of the dependents are there?
5 euros.
5. Correct ಇದೆಯಲ್ಲ?
Income has to be.
ಎಷ್ಟಕ್ಕೆ? How much has to be enhanced according to you?
Yes, that was earning 30,000.
30,000 is to be given.
If they were to produce,
All right. Estate and other thing is given. Yes, sir.
But only income, as per the fact, you need to consider that income, total factor.
ಬಾಕಿ ಎಲ್ಲ correct. That's all. You have not read your papers and the judgment of the Supreme Court. So you don't need that 10%. You don't want. You don't want. Which 10%? Which 10%?
next,
Which,
gratify this one.
or why it should be granted? Under which judgment says so? You ಕೂತ್ಕೊಂಡು ಆಫೀಸಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಓದೋದಿಲ್ಲ. Youngsters should read the judgments. You won't read Pranay Sethi.
When I say
ಅದು ಕೊಡು. ಬರ್ಕೊಳ್ಳಿ. Date of accident 2/11/2018 at 8:15 p.m. Claimants are the legal representatives of the deceased Ramachandra, being the wife and 3 minor children, and the mother, age 60 years. Though claimant have contended that deceased was working and earning rupees 30,000 by doing agriculture, no documentary proof is produced to show the income. Tribunal has taken the income at 12,000 per month as notional income. The Legal Services Authority chart describes notional income at 12,500 for the accident year 2018. Same requires to be awarded accordingly. Income is taken as 12,500 per month. Age of the deceased was 32 years as on date of death. The multiplier adopted by the tribunal of 16 is correct, does not call for interference. Tribunal has rightly awarded 40% in addition to the income as future prospects, and deducted 1/4 of the income towards personal expenses of the deceased, which also does not call for interference. Calculation ಮಾಡಿದಿರಾ? $13,125 ಬರುತ್ತಾ income? Income shall be taken as 13,125 per month after deduction and addition of the future prospects. Since 13, the loss of dependency would be 13,125 into 12 into 16. $25 lakhs 20,000, which would be 25 lakhs 20,000. as against 24 lakhs 19,200 awarded by the tribunal. Towards consortium, tribunal is awarded totally 2 lakhs, the form of loss of consortium, loss of parental consortium, loss of filial consortium. Towards funeral expense and loss of estate, tribunal is awarded 15,000 each, in all 30,000. Same does not call for interference except for awarding 10% on the loss of consortium and 10% in addition to the loss of conventional head in accordance to the judgment of the Honorable Apex Court in the case of Pranay Sethi. Should be 2 lakhs plus 10%. 2 lakhs 20,000. So 20,000. 20,000 in addition and 3,000. 3,000 in addition. 3,000. Will have to be added. In view of the above, claimants, the claimants would be entitled to total compensation of dash as against 26 lakhs 49,500. As per the table mentioned here and below. Accordingly, I pass the following order. Appeal is allowed in part. Claimant is entitled to total compensation of dash as against 26 lakhs 49,500 with interest at the rate of 6% per annum in the date of petition till realization. All other terms and conditions stipulated with regard to apportionment as laid down by the tribunal is not disturbed. The balance compensation amount and hence compensation amount shall be paid within a period of 4 weeks from the date of receipt of copy of the order.
Yes.
Really, new counterpart ಇಲ್ಲಿ
Srinivas Farad.
injury case. Liability is admitted. Is he available? Srinivas is the counsel for insurance company. Idhar, you want passover? Passover. Shastri ji.
Ravishankar Shastri.
Idhar alla, Hegde.
Yes, my lord. I appear for the respondent.
Ready alla, Hegde, you're ready.
Yes, my lord. Death case, it can be disposed of.
Yes.
Date of accident is 14/2017. Deceased was in 43 years. Widow and 3 children are parents. Date of payment was that he was getting 15,000 per month for the by working at a tractor plus
Working as
tractor plus
tractor buster.
Yes.
ಏನು ಹೊಸದ
But I
ಅದರಲ್ಲೇನು ಜಾಬ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇದೆಯಾ ಅದು ಟ್ರ್ಯಾಕ್ಟರ್ಸ್ ತಗೊಂಡು ಬಸ್ಟ್ ಮಾಡೋದು ಗೊತ್ತಿದೆ ಟ್ರ್ಯಾಕ್ಟರ್ ಬಸ್ಟರ್ ಸಪರೇಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇದೆ
yes. Festival seasons and all.
they will be called. So what is the income for them?
The employer was examined and they stated that was paying 15,000 per month.
1.5. What is the document?
That is certificate was just.
Is it disputed by him? Same is awarded by the tribunal.
No, my lord. The tribunal pays monthly income at 6,000 per month.
It took 9,000.
Yes.
So you want 15 or you want the chart?
But my application was not.
So income is 15 according to you.
Yes.
So you examined home PW.
PWC, my lord, has quite a deal of that. And exhibit B18 salary certificate.
BW3.
However, my lord, that.
Where is your salary slip? Exhibit?
500 per day, my lord, exhibit B18.
So that is not accepted by the
It
tribunal.
was not accepted. The ground that accept these documents, no other documents were placed on record.
So MACT has given 9,000.
Yes. Then there were 4 dependents.
So chart is 11,000.
Yes.
Mm.
Since you were saying 43 years, 25% of future profit have been awarded by agency, which is not there.
Mm.
Then there were 4 dependents. Deduction should have been 1/4 instead of paid by agency.
ಎಷ್ಟು ಡಿಪೆಂಡೆನ್ಸಿ ಇದಾರೆ?
Not them.
4.
So, wife and 3 children.
So 1/4.
1/4 ಮಾಡಬೇಕು, 1/3.
So deduction should be 1/4.
Then we got a convention that we got 20,000 was awarded to the widow minor as consortium. It was supposed to be
Sorry, which one?
consortium to wife was awarded at least 20,000.
Consortium.
Yes.
Only 20,000 is given.
To the wife, and 3 children are awarded with 20,000 each male.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು?
But that is
40,000 is given.
Page 17, my lord.
17 my lord.
40 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ?
Yes. Awarded affection 40,000. And my lord, loss of consortium 20,000. That is 40,000 was awarded to my lord 3 children. Should have been my lord, loss of parental consortium my lord.
All right. So totally consortium is 60,000 ಕೊಟ್ಟಿದ್ದಾರೆ. According to you, it should have been 4 ಅಲ್ಲ dependents?
4.
160 ಕೊಡ್ಬೇಕು. 160 you should get.
Yes.
Instead of 60.
Yes.
Transportation is correct, estate is correct.
Yes.
That's all. Yes, Mr. Hegde.
Yes, my lord. Regarding income, my lord, your lords may kindly say, my lord, he says that he has examined the employer, but no, apart from producing the salary certificate by him, my lord, no other credible evidence has been produced before the tribunal. Accordingly, my lord, the tribunal taking into consideration the factual position, my lord, 9,000 has been considered. But my humble submission is, my lord, now, my lord, the Lok Adalat chart is accepted uniformly. So, as per that Lok Adalat chart, 11,000 is applicable. So, that can be taken, my lord. And my learned friend is right, my lord, that the future prospectus of 25% has not been added. So, that can be also be, my lord, it is not from my side, but I am submitting that, my lord, the compensation, total compensation award is just and reasonable. But, my lord, in view of the judgment of the Supreme Court, that 25% is to be added. Further, regarding, my lord, this other conventional heads, my lord, the lords may kindly appreciate. It is a disputed question, my lord. Now, my lord, in view of the Bhagat Singh Rawat case, my lord, my learned friend also knew about that. The latest judgment of Supreme Court, in view of the Pranay Sethi case, my lord, as your lordship is aware, my lord, Pranay Sethi speaks, my lord, only 70,000 under the conventional acts. Then, my lord, Magma came and my lord, Satyendra's case came. There, my lord, it has been held, my lord, 40,000 each. Then, my lord, latest judgment of Supreme Court in Bhagat Singh Rawat, my lord, only 70,000 has been considered. And subsequently, my lord, in view of 2023, almost all Supreme Court judgment, only 70,000 has been granted by the Honorable Supreme Court. That's why I leave it to the issue, my lord, regarding loss of consortium to your lordship, my lord. Other heads, my lord, it can be considered, my lord.
Where is that Bhagat Singh's case?
My learned friend not also that, my lord.
Huh? Sorry? Where is that Bhagat Singh case, Mr. Hegde?
My lord, Bhagat Singh case is, my lord, my learned friend is also aware, my lord. Today I am not in a position to
He's
produce
aware,
that.
but I am not
I will,
aware.
my lord, just.
Both of you are aware. I am not aware.
My learned friend is aware. He has got that judgment very much, my lord.
Sir Ligade, you are
Yes, my
very
lord.
fast. I am not so fast as you. I need to be
Yes, my lord.
aware.
That, just, my lord, I will read out that Bhagat Singh case, my lord.
What is the bench strength? Have they distinguished Pranay Sethi and Satinder Kaur?
Three judges.
Have they distinguished it? How can they
My lord,
distinguish
Bhagat
other?
Singh,
By the itself, I am not what's been awarded by the and in fact,
Bhagat Singh's case is bench quorum was 2.
my lord, and they say no vendor section has to be as per Pranay City, which is not the
Which
but
is,
Pranay, my lord, my humble submission is that
let me also read the judgment. Give me the citation.
my lord, this is, my lord, this
Which is that?
reported, my lord, this judgment dated July 4, 2023, my lord. In my lord, civil appeal number 3900 bar 2023, my lord.
You provide the citation.
Yes.
That's all.
That's why, my lord, I will leave to my lord regarding my lord, the matter can be disposed of because now, my lord, this substantial enhancement will be there, my lord. And your lordship may kindly appreciate, my lord, there is a hike in the, my lord, income from 9,000 to 11,000. And also deduction is also your lordship adding. And further, my lord, this one future prospectus is also considered. So that's why I think there will be no injustice to the petitioners, my lord. And the matter will be settled at the earliest, my lord.
No, I'm settling it today now.
Yes, my lord.
Deceased Razab, said to have died on 14/5/2017. He was aged 43 years. Income is said to have been 15,000 by the claimants. And he was employed as a minister. It is certified by PW3, the employer, by producing salary certificate at Exhibit P18 to show that he was earning 500 rupees per month. 500 rupees per day. Per day. However, the tribunal has negatived and not believed evidence of PW1 and PW3. Also, Exhibit P18 has awarded a notional income of 9,000 rupees. Whereas the Legal Services Authority chart of Lok Adalat describes notional income of 11,000 per month. The deceased was aged 43 years. The appropriate multiplier is taken at 14, huh? 14, which does not call for interference. The tribunal has deducted 1/3 towards personal expenses, whereas the deceased has left behind 4 dependents, and the deduction towards personal expenses ought to have been taken at 1/4 rather than 1/3. The tribunal has failed to award future prospects in view of deceased being aged 43 years. 25% would have to be added to the income as future prospects. 7,000. 750. $10,313. 10,313 would be the income to be taken for calculation. Therefore, the loss of dependency would be 10,313 into 12 into 14. 1732,584. Correct? 1732,584. Towards the consortium, tribunal is awarded 60,000 under the head loss of affection and consortium. Whereas there are 4 dependents left behind by the deceased. Each would be entitled to 40,000 per person in view of the judgment of the Constitution bench in the case of Pranay City. Hence, they would be entitled to 1,60,000, which would also secure 10% interest for a block period of 3 years.
10% escalation, my lord. Escalation.
Escalation, 1,60,000. Should be 16,000. Mr. Ma? 16,000. The convention, the loss of estate transportation of dead body or funeral expenses of 30,000 in all. It also fetch 10% escalation of 3,000 in addition to what was awarded by the tribunal. Accordingly, claimant will be entitled to total compensation of dash amount as against 10,98,000 as per the table mentioned below. Accordingly, I pass the following order. Appeal is partly allowed. Claimant is entitled to total compensation. Claimants are entitled to total compensation of dash as against
41,584.
19 lakhs
41,584.
584. 17 as against 10,98,000 ordered by the tribunal.
My lord, my contention may kindly be noted, my lord.
Yes, yes,
Sir.
yes. Interest line same. What is the interest?
My lord.
6%. All other terms and conditions stipulated by the tribunal stands intact. The balance enhanced compensation shall be paid by the respondent insurance company within a period of 4 weeks.
Yes, my lord. On receipt of the judgment.
That's all. This next paragraph. So, vehement contention of learned counsel for the insurance company Sri Hegde that the consortium awarded by the tribunal does not call for interference in view of the latest judgment of the Honorable Apex Court in the case of Bhagat Singh and others also.
Shriram General Insurance Company Limited versus Bhagat Singh Rawat, my lord.
Wherein the total amount awarded towards conventional head is 40,000 plus 30,000, in all 70,000, and not 40,000 per person, as argued and canvassed by the learned counsel for the appellant claimant. I'm afraid this contention of the learned counsel for the respondent cannot be accepted for the reason that the larger constitution bench of the case of Pranay City And thereafter, the full bench, in the case of Satinder Kaur, has said 40,000 per head per person to be awarded as consortium.
Sorry for interrupting. To make it, my lord, to bring to your lordship's kind notice. My lord, Pranay Sethi says 70,000, but Magma General Insurance Company made it 40,000 each. my lord. Their exposition of law was made. Magma General, yes, Magma General
40,000 per
Magma
head.
Company Limited, my lord.
40,000 per head is cited by Magma.
Magma, my lord.
Magma.
Pranay Sethi speaks only about 70,000.
But later on in Satinder's course, which is
Satinder case also, my lord, speaks about, my lord, this Magma General Insurance Company, my lord, law has been laid down, my lord, in those two cases.
Magma and Satinder course is 40,000 per head. Hence,
And also, my lord, Janabi case also very latest 2022.
This court is of the opinion that 40,000 per head is to be, per person is to be awarded. Yes.
Apply, my lord.
Yes.
Arjun. 57. Do you have any?
I agree.
Yerama, I didn't get you.
But we call it after 2 weeks. I will also accept it. But in the 80th road, in the rail was not. The accepted by looking to be morning will be called to say.
We'll have it after 2 weeks.
And right, then the district court.
At request of learned counsel for the appellant and respondent, release this matter after 2 weeks. Learned counsel for the appellant and respondent, then counsel Sri Ravish Penny undertakes to appear on behalf of, undertakes a direction maker. Is directed to take notice for respondent number 4, United India Insurance Company Limited. Full stop. You want to refer matter is referred to Lok Adalat.
59. Pramod B.
Where is your opponent? He is required. A claim petition is dismissed.
Thank you. Here, ಬೇಕು ಅಂತ morning.
Okay. Registry to secure trial court records. Released next week. Yes. Ramesh. Manjula. Yes, madam. Yes, sir. Future prospects given. Reduction is correct. Multiplier is correct. So what is the amount? Accident is of the year 2014.
40 years.
Age 40, no dispute.
No dispute.
Income,
Income, the title has taken at 8,000, as per the chart, comes to 8,000.
according to him, what is the income?
They have not proved their income and the vocation. Therefore, as per the chart, prepared with the legal service department on the discount report. That is 80,500 per month. So the accident in the year 2014.
14, 8,500. What has taken by the MACT?
8,000 there. 8,000.
Which paragraph?
On page 23.
Para?
23.
23.
8,000 on page number 24, your lordship. On page number 24. From the materials on reference is very often that the action to pay the existing body has operated. To say that any of the income of the city is something that.
Ah. 40 years. Future prospects is correct.
25% only. And he was above 40 years. So above 40 is 25%.
25%.
That has been considered the then
That has been given.
Yes, yes. And even now,
Multiplier.
multiplier 15.
Reduction.
One.
1/4.
Yes, there are 4 dependent.
That is also given.
Two children and mother.
That's also correctly given. What else remains? Huh?
Even that, the consumption also got a 60,000, 40,000 actually given, that is 1,60,000. Towards funeral expenses and loss of other affection, funeral expenses and loss of estate, they often have given 15,000 each year.
40. Why 40 that?
So if it is recalculated, reconsidered, reassessed the capital compensation, there will be a difference of around 65 to 70.
No, where's the question of reassessment? You are not in appeal. No, instead of giving that additional amount of 10%, I will not give that. It can get adjusted here. What is the additional amount that you get? 8,500.
Yes, sir.
You've done the calculation?
Yes, sir. 8,500 into 25% reduction. It comes to rupees 2,125. That is the total difference. Together it comes to 10,625 is the monthly income. 10,625 into 1/4 years. This is the 4 independent. 2,056 will be the. That's the person expected to the decrease.
7,996 into 12 into 15. 1,439.
Yes.
280. You just put it there. 1,350. 60.
Reduction 1/4, which comes to 2,656. 10,625 2,656 minus 7,9,699. 699.
Not 969.
7,969.
Being 34,420. All right. So we'll modify it. Even otherwise, you'll get more than 16 lakhs 40. So I'll modify that into 15 plus 15 of the estate and funeral expenses and provide 10% enhancement escalation. That's what.
10% towards, on the enhanced compensation, the interest. And so far as the other affection, the consortium and the
160.
10%.
160 plus 10%. 30,000 plus 10%. All other things are same. The deceased. Siddhigowda, na?
Yes.
Siddhigowda. Billion writer Siddhigowda. What's the name of the, who's the deceased? Devaraje Gowda. Deceased Devaraje Gowda died, succumbed, met with a road traffic accident on 20th April 2014. He was aged 40 years as on the date of occurrence of accident. No documentary proof of income is placed before the court. The tribunal has taken notional income of 8,000 per month. Whereas the Legal Service Authority chart, Lok Adalat prescribes 8,500 for the accident year 2014. One is required to be taken as income of the deceased for computation. Tribunal is awarded future prospect at 25 in addition to the income of 25%. And the multiplier is calculated at 15 in accordance to the judgment of Sarla Verma's case, which is correct and does not interfere. So also the deduction towards personal and living expenses is taken at 1/4, which does not call for interference. Loss of dependency should be 8,500 plus 25%. Would be 10625. 1/4 deduction would be 10625 minus 2656, which is 7969. Therefore, 7969 into 12 into 15 will be 14,34,420. The tribunal has awarded consortium to an extent of 1,60,000 under the head love and affection to all the claimants, 4 in number. For the judgment in the case of Pranay Sethi, just followed in the case of Magma and Satinder Kaur, which is rightfully calculated, and the same does not call for interference except awarding 10% escalation towards a one block period of 3 years. It should be 16,000 in addition to 1,60,000. Tribunal is awarded funeral expenses 20,000 and loss of estate at 25,000. Which appears to be on the higher side. I'm in agreement with the learned counsel for the respondent insurance company that the same should be reduced to 30,000 as contemplated in the case of Pranay Sethi. Full stop. I'm also in agreement with the learned counsel for the appellant claimants that 10% requires to be awarded on the conventional head of consortium and the funeral and estate. Therefore, 16,000 plus 3,000 requires to be added to the total compensation. So the total compensation, the claimant should be entitled to total compensation of
16,43,420.
16,46,000.
43,000.
43,420 as against 15,55,000. As per the table mentioned here in below. In view of the above, was the following order. Appeal is partly allowed. Claimant is entitled to total compensation of so and so as against 15,55,000. The responding insurance company shall pay the balance enhanced compensation amount. Huh? Correct. Whatever is that? Within a period of 4 weeks, in the date of receipt of copy of the order, all other terms and conditions stipulated by the tribunal stands intact regard to apportionment and deposit in the fixed deposit of fixed deposits. Nothing else? So.
Number 61. In this case also.
Request of learned counsel for the respondent released next week.
62 dismissal withdrawn. 63. Tripadi Shastri.
Shastri,
Yes, my lord. Yes, sorry, my lord.
Fresh matter.
The fresh matter, my lord, notice may kindly be issued. And if possible, my lord, I will file the necessary memo. Notice to R1 may kindly be dispensed.
issue notice to respondent. Number?
Respond number 2, my lord.
R2 notice of better.
R2 notice.
Issue notice to R2. Learned counsel for the appellant files a memo seeking dispensation of notice to R1. Notice to R1 is dispensed as liability is admitted by R2. Memo you have to file, Mr. Shastri.
Yes.
64. The Shastri.
Mr. Ariga. Shastri, Balakrishna Shastri. Password.
First matter number 47.
You ready? Are there?
Everybody back in the donor. Okay. They are what regulations. And the money to the court. Need evidence. We go to court.
The claim petition came to be dismissed. Oh, against the owner.
Everybody fixed on one of the main court. They are not entering evidence. They are not putting the regulations. Go to the appeal.
So why it is fastened on the owner? Because of no insurance.
No, insurance is there, but we are not related to regulations.
So the fastening of the liability on the owner is because of not having driving license.
No, he was
No, the trial tribunal ಏನು ಹೇಳುತ್ತೆ?
No, one person very clear on the data that the response is not also valid, very clear to you. You know, to see.
Para 12, you are reading where?
14.
Third respondent to the
Now
content.
they came out now. They came now, they came out that they have driving license. They have a copy of the driving license. That's all. Let them produce for the lower court and let them read evidence. Substantiate that they are got driving license. And basically can say that. Sure. Maybe remind the facts to the lower court.
So produce here the driving license.
No, it's not.
Now they have to be.
No,
Where?
here, that's it.
No, you have produced or you are having it with you?
No, actually, what happened, the dealer was lost. And they have produced the B extract. At the time of, in 2016 or 18, the RTO has transferred from 32 to 63. So extract was issued on 2018, but which was not updated. But in the software, it was updated and dealer was valid. From 22/8/2016 to 21/8/2019. On the date of accident, it was valid. So I have produced the extract of the RT3 consumption software. So on the
Where have you produced?
here,
Delhi.
here, page number 35.
You have filed along with some document.
Yes, my lord. That is the copy of the extract. It was issued by the RTO of Shimoga. Page number 35.
The page edition, which 35?
$35.
Yes.
DL for transport valid from 22/8/2016 to 21/8/2019. Left side.
Which vehicle license is this?
Transport.
Transport license. 22/8/16 to 21/8/19.
19. Date of accident was 16/10/2016.
You're not given copy to him?
Give a copy.
Hmm.
Or laptop copy of law. and when they remanded to the court, then they decide other issue only you will ask. The particular issue. So because of the direction, because of the previous man. The direction.
So you are disputing this,
I don't listen to the copy now.
closely, okay?
I verify for the second registration free. They verify and it's valid.
These applications filed by you are allowed?
No.
So you want to lead evidence on this?
Letting give evidence, but reading these documents. That's what we decide. And the issue and the level they are left with side.
Good. The appeal is preferred by the claimant. Owner of the offending vehicle. Being agreed by the judgment and award passed by the tribunal. By the additional MACT 14 Senior Civil Judge Tirthahalli in MVC number 717 of 2017, dated 23rd December 2019. Parties to the proceeding shall be referred to as per the status of the tribunal. It's a case of injury, alone. Case of injury. Claimant has filed a claim petition seeking compensation for the injury sustained in the road traffic accident having occurred on 16/10/2015. While the claimant was proceeding on a motorcycle bearing KA-14 EF7361 as a pillion rider. Who was the rider? Respondent number 2, is it? Who was the rider?
Respondent number 4.
Owner and rider. Along with the respondent number 4, who was the owner and rider of the motorcycle? When the motorcycle was flying, was being ridden at the near Kavale Durga Cross, Yadahalli village, Tirthahalli Taluk, at 8:45 a.m. A lorry bearing registration number KA-270023 belonging to the first respondent, driven by the second respondent, came from the opposite direction in a rash and negligent manner and dashed against the motorcycle, thereby causing the accident, due to which the claimant suffered severe grievous injuries to his body. Accordingly, claim petition came to be filed by the claimant seeking compensation against the respondents who are the owners and driver of the offending vehicle, and so also the rider of the motorcycle in which the claimant was a pillion rider. Anybody remained ex parte or all appeared before the tribunal? ಎಲ್ಲ appear ಆಗಿದ್ರಾ? Respondents 1 to 4 contested the claim petition, filed the statement of objections. And after hearing the parties, the tribunal allowed the claim petition and awarded a total compensation of 4,13,500 with interest at 6% from the date of petition till realization. Along with interest of 50,000 towards future medical expenses. Petition not entitled for it. Along with the 50,000 towards future medical expenses, interest 50,000 towards future medical expenses. The tribunal directed the respondent number 1 to be liable to pay the compensation to the claimant, 6% interest. Being aggrieved by the judgment and award passed by the tribunal, the respondent number 1, owner of the offending vehicle, before this court, challenging the legality of the same. The counsel for the appellant, this respondent number 1, contends that the judgment and award passed by the tribunal is contrary to the material placed on record. The same is liable to be set aside as the tribunal has not taken into consideration the spectrum of the liability that requires to be fastened on the insurance company as the policy was in force as on date of occurrence of the accident. When counsel for the appellant, respondent number 1, when counsel for the respondent number 1 has filed IA 2 of 2020 for production of additional documents, wherein he seeks to place reliance on the driving license and the validity of the same from 22/8/2016 to 21/8/2019. This document is produced before this court for the first time, and the same has not been relied before the tribunal. The reliance placed on this document requires to be tested before the tribunal for passing any further orders. Therefore, the short point for consideration before this court in view of the additional documents placed before this court is whether the matter could be heard without referring it to the, remanding it to the tribunal for adducing further evidence and providing an opportunity to the respondent insurance company to cross-examine the witness and speak about the document relied on by the appellant here. More so in view of the fact that this document is now placed before, is filed before this court for the first time. In the circumstances, court is of the opinion that if the matter is remanded to the tribunal for consideration of the additional document placed before this court, that is the driving license of the appellant to be in currency as on date of occurrence of the accident, justice would be rendered to both the parties as the appellant would have the chance of placing the driving license and leading evidence on the same. So also the respondent insurance company would have the opportunity to cross-examine the witness on the said driving license, which is filed before this court for the first time. So under the circumstances, The reason stated here in number or pass the following order. The appeal is disposed of, remanding the matter to the jurisdictional tribunal to consider the driving license produced before this court by the appellant herein, provide an opportunity to the appellant to lead evidence, the production of the said document, namely driving license. We shall provide an opportunity to the respondents and other, including the claimant, to cross-examine the witness on the said additional document and any other document that would be placed before the court. The tribunal shall dispose of the matter within a period of 3 months. Within a period of 3 months. Full stop. It is made clear that this court has not expressed any opinion or made any observation on the merits of the matter, including the driving license so produced before this court.
Driving license of the respondent number 2. Driving license of the respondent number 2. Who is the driver of the lorry? Appellant is the owner of the
Driving license of respondent number 2, the owner, the driver of the lorry.
deposit amount may be
You have deposited.
before the driver.
The amount deposited before this court by the appellant shall be. ಇಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ
ಇಲ್ಲ ಅಲ್ಲಿ
ಅಲ್ಲಿದೆ.
maybe refunded.
That you go and ask them.
ಈ
You're deposited before the tribunal. The
order of this.
what is that? What is it? The entire award amount you have deposited.
50%.
50% while getting stay.
Like the speed there, even maybe
Just let him take it back. If there's going to be a different order or that directing you to make the payment, then why it should be lying in the bank or the court? Even whether he succeeds or not, I don't know. That is based on your evidence. So if he succeeds, then this amount anyway will have to go. Huh? No, whether he wants to challenge thereafter or not, that I don't know. The trial court shall disperse the amount deposited in favor of the appellant herein of an amount of 50% of the amount deposited as per the orders of this court by the order dated 16/12/2020. Correct? You have deposited as per the order of 16/12/2020. Records shall be transmitted to the jurisdictional tribunal forthwith.
Another one. 47.1.
Same?
Same.
Other lane, no?
Same. Arising out of the same accident.
Pillion ride.
First case was filed by the pillion rider, and the second one is from the rider of the
Same order. Same order.
and the deposit amount may be refunded to the appellant. It is deposited before this court.
Order.
In this
The amount in deposit made by the appellant before this court shall be refunded and dispersed to the appellant upon proper verification.
also.
Huh? Where is your friend?
Yes, I can.
He's here.
Yes.
Hmm.
Every is for last.
Hmm.
4,000 rupees. 1% after earnings. Yes.
So what is in dispute?
2019 actually.
All right, income is correctly taken.
No, it has to be increased.
Just put it there. What is the age? What is the age?
Age was, 38 years.
Huh?
Even as considered as much.
41.
14 multiplier.
41 is correct. Multiplier is 2.
40.
Income by the tribunal.
10,000. 10,000 is.
Huh?
10,000 is assessed by the tribunal.
10,000.
14,000 is taken.
Hmm. What's the disability? Which paragraph? Which paragraph? PW2 Dr. Somashekar. Total disability at 58%, whole body 29%. In Ray, ಜೋರಾಗಿ ಹೇಳ್ಬೇಕ್ರಿ.
29 is.
What has the tribunal taken?
We are assessed 10%.
Huh?
12%.
12%. Yes, what do you say on that?
Limit is particular limit is 58%.
Correct.
So it must be 30%, 4% is.
Total disability of right lower limb. 58% ಅಂತ ಇದೆ.
So 1/4 is. 13. 12.4.
1/4.
1/4%.
What is this 1/4 new one?
One third, sorry.
Ah.
Total is one third actually.
ಮತ್ತೆ 1/4 ಅಂತ ಇದೆ.
Sorry.
How this disability to the whole body of 29% is arrived? How? What was the avocation?
He was head motor mechanic at CH-16.
Head motor mechanic. Tribunal is second 12%, so it should be 19%. What else? What about other aspects?
Soft tissue or the lateral of the right knee, multiple occasions for the head and the right shoulder, internal rotation of the humerus.
How many trees, sir?
20,000.
Hmm.
Another 20,000.
Now, how many fractures? Where is that?
There are 3 factors.
Where is it mentioned? Page? Page 12. Para 12. Hmm. So 3 fractures. So 25,000 into 3.
Not like
Huh?
which individually, you know, not like that. Total sum of 40,000.
Now, how is that 40? Is it some guesswork? Now, who has stipulated this general method?
Each injury is not. Earlier it was 15,000 per injury.
Hmm.
Later, lump sum of 160.
Lump sum of?
Lump sum 40,000, 50,000, depending upon the next activity.
So that will come under the
Loss of amenities.
loss of amenities. So loss of amenities means 20,000 is awarded.
Yes.
We will make it 50,000 will make.
The loss of even during later period.
Will increase.
10,000 is granted.
14,000 into ಎಷ್ಟು ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ?
Only for 2 months. 2 months is considering that 3 months.
4 months.
No.
Huh?
4 months.
56,000. 14,000 into 4 months.
Then the
Ah.
20,000.
Minus 20,000.
Yes.
Then how many days he was inpatient?
15 days.
Huh?
19 days.
19. What is awarded? 15 days.
10,000. Another 4,000.
Another 10,000 can be. Medical expenses actual,
Actually.
pain and agony is correct. What about future medical expense?
No, no.
Huh?
Doctor agency.
ಇದೆಯಲ್ಲ stated.
Future medical expenses. So far, not.
ಡಾಕ್ಟರ್ ಹೇಳಿದಾರಲ್ರಿ 50,000 ಕೊಡ್ಬೇಕು ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ನೋಡ್ರಿ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ನಾವೇ ಹೇಳ್ಬೇಕ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. Why don't you read your papers? What the doctor has said? The judgment says he has said 50,000. ಇಲ್ವಾ ಎವಿಡೆನ್ಸ್? ಏನು ಎಸ್ ನಾನು ಹೇಳ್ದಕ್ಕೆ ಎಸ್ ಅಂತೀರಾ? ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲೇನ್ರಿ? ಡಾಕ್ಟರ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಇಲ್ಲ. ಓದಿ ಮತ್ತೆ. ಫೈಲೇ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? ಫೈಲ್ ಇಲ್ವಾ? ಫೈಲೇ ಇಲ್ಲದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ನಾವೇ ಮಾಡ್ತಾ ಇರೋದು ನಿಮ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್. See para number 12, internal page 13 of the last page 14 of the judgment. ನಿಮ್ಮ ಹತ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ? ಜಜ್ಮೆಂಟ್ ಇಲ್ವೇನು? ಟ್ರಿಬ್ಯುನಲ್ ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ. ಎಲ್ಲಿದೆ? ನನ್ನ ಹತ್ರ ಏನು ಪೇಪರ್ಸ್ ಎಲ್ಲ ಎಲ್ಲಿಂದ ಓದ್ತಾ ಇದ್ದೀರ? From where you are reading? Huh? Judgment is online, is it? Just read it. Come to the relevant portion of future medical expense. $50,000 ಹೇಳಿದ್ದಾರೆ. Since he has said 50, what is given is 25. We'll add another 20. That's what. Accident is occurred on 20th June 2019. Age of the claimant 41 years as on date of occurrence of accident. Income is taken by the tribunal of 10,000 per month. As notional income. There's no material produced by the claimant in proof of income. However, the notional income chart, the Legal Services Authority for the accident year 2019 prescribes 14,000 per month as income, which is taken in the present case on hand. The appropriate multiplier applicable to the present case would be 14, which is correctly taken by the tribunal, and the same does not call for interference. PW2, the doctor has opined that the claimant has sustained disability to right lower limb at 58% and the whole body at 29%. Whereas the tribunal has, on examination, has found the whole body, has awarded whole body disability at 12%. Even if for the 58% towards right lower limb is taken into consideration and 1/3 is deducted towards the whole body, the disability would come to 19%. Once the disability is requires to be taken at 19% as against 12% taken by the tribunal. Therefore, the loss of earning capacity due to his disability would be 14,000 into 12 into 14 into 19%. Election ಮಾಡಿದ್ರೇನ್ರಿ? It should be 4,46,880. As against 2,01,600 awarded by the tribunal. The tribunal is awarded sum of rupees 60,000 towards pain and agony, medical expenses at 6,363, which does not call for interference. Towards food attendant charges, nourishment, and other incidental charges, 6,500 is awarded, whereas the claimant was inpatient for a period of 19 days. Therefore, it would be appropriate to award an additional amount of 10,000 under this head. Towards loss of income during later period, tribunal is awarded 20,000 in view of enhancement of income by this court to 14,000 per month. And the claimant will require at least 4 months period to recuperate and get back to his normal day-to-day activities. 14,000 into 4 would be 56,000. Minus the amount awarded of 20,000 would be 36,000. Under this head. Towards loss of amenities in life, tribunal is awarded 20,000. I deem it appropriate to award 50,000 under this head. Towards future medical expenses, the Dr. PW2 has stated in his evidence that 50,000 rupees would be required for removal of implant. Same requires to be awarded. Accordingly, future medical expenses is awarded at 50,000 as against 25,000 by the tribunal. In view of the above discussions, claimant claimant would be entitled so and so for the table mentioned here, and accordingly I pass the following order. Appeal is partly allowed. Claimant will be entitled to total compensation of dash amount as against 3,39,463. All other terms and conditions stipulated by the tribunal stands intact. Claimant shall not be entitled to interest for future medical expenses at 50,000 awarded by this court. The balance enhanced compensation amount shall be paid by the insurance company within a period of 4 weeks from the date of receipt of copy of the order. Anything else? Serial number 54. Yes, Mr. Vijay Kumar. Howdo? 70. Hmm. 70. What do you want? Yes. Are you ready? Report ಬಂದಿದ್ಯಾ ಮಾತ್ರ? It is arrived. ಏನ್ ಮಾಡ್ಬೇಕು? ಕೋರ್ಟ್ ಏನ್ ಮಾಡ್ಬೇಕು? ನೀವು ಯು ಮೇ ಕಮ್ ಏನ್ but I will come. You may come, may not come. Next Friday, he is not here. Week after next week. At request of Senate Council for respondent 1 and 2. Release this matter week after next. 70? ಇದು ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಲ್ಲ 77. Adra, that on that ground only they have taken action. Huh? Itaralla Vijay Kumar. Afternoon jointly you are having some difficulty. When do you want? Next week? He is not here next week. Week after next. 74 at request of both Learned Council release week after next. You are appearing for IFCO Tokyo. ಅದು ಬೇರೆ ಯಾವ್ದಕ್ಕೆ ಯಾರಿಗೆ ಸರಿ No, for the IFCO Tokyo, anybody else's name is given. Some other registry to show the name of Learned Council Sri D. Vijay Kumar as council appearing for R2 in the cost list. Yes. 72, yes, sir. Really? Huh? Number really? 2931 of 22. 20 registry to list the said MFA along with this appeal. Relist next week. Are I thought you had more than that.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಏನಾಗಿದೆ ಮೇಡಮ್? ಮೇಡಮ್ ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಸರ್. ಹಲೋ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಮೇಡಮ್. ಹಾ ರಿಪೀಟಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಯಾರಿದ್ರು?
ಯಾರು ಇರ್ಲಿಲ್ಲ ಡೈಲಿ ಬೆಳಗ್ಗೆ ಏನ್ ಅವರು ಇವರು ಸರ್ ವೃಷಭೇಂದ್ರ ಅವರಿದ್ರು ಇವ್ರಿರ್ಲಿಲ್ಲ.
You are appearing for whom? So it is remanded only for considering that aspect of medical, the DL. ನಿಮಗೇನು ಅದು ಎಫೆಕ್ಟ್ ಆಗಲ್ಲ. No problem. ಅದರಲ್ಲಿ have you received that copy of that additional document? DL he has produced. His case is that during that period, driving license was there. If his contention is accepted, it will shift to the state. I have given liberty to you also, if you want to proceed.
Pastor matters 64. Krishna Shastri.
Hello?
64.
Krishna Shastri. I have not heard this one. It was called out the second time, 2:46 p.m. There is no representation. Balakrishna Shastri, 64.
Sorry, once.
No representation on either side. We'll discuss this matter next week.
Notice.
ಇದ್ರಲ್ಲ.
Admission Krishna.
ಇದ್ರಲ್ಲ.
ಅವರು KV8. R1 and 2. There are 11 responses. Next.
Issue notice to the respondents.
Other arguments. Number 65.
I apply for respondent number 125 and respondent number 729 minutes.
ಇದು ಆಗಿದೆಯಾ?
My last have heard the matter at length.
Can you just brief me? Jerry, just brief me.
This is case where mother enters into a partnership with his brother, including the rights of the minor. Thereafter, relinquishes in favor of his brother entire property. Therefore, the for partition and 1954 transactions commenced in 1990s was filed.
May I request my loss to have the matter on Monday?
There are further arguments ಇದೆಯಾ?
If my lords want us to refresh the facts, my lords, we would assist the court.
All right, we'll have it on Monday. Tuesday, Monday. 8. At request of counsel for the respondent. Release this matter on 8th January.
Mature.
Both of you have filed any synopsis?
I have both of us.
Filed. And then just refresh, that's all.
Please.
Finally, number 66, Rajshekar K.
Rajshekar.
Injured person, amputation of left leg, for enhancement,
amputation of the left leg.
is above the knee. Enhancement of the arm.
Where is Lingaraj? Lingaraj is for the insurance company.
Yes, please.
And Hanumantappa is R2,
Owner of the vehicle are to liability is satisfied by the insurance company.
satisfied.
Please,
So liability is not in question.
not in question.
Only the quantum.
Please.
Or ಬರ್ಬೇಕಲ್ಲ. So Lingaraj will have to answer you.
Please, please.
ಇಲ್ವಾ ಬಂದಿಲ್ವಾ ಇವತ್ತು ಅವರು?
Yeah.
You have his number. Just call him if he's available, you bring him, I'll hear you. Otherwise, there's no point waiting.
Please, please.
No, I'll call it after some time.
768.
Ramakrishna.
But the operator was the owner of the vehicle. Not that the earlier, the respondent was not filed of state claim in Mulbagal. Then I appeared as a respondent number 2, I filed a follow-up claim. And the appellant, the claimant, filed a memo for to withdraw the petition, that is not switched off. Subsequently, not the same claimant filed claim petition before the Neon court, giving the wrong address. Hence, I am placed expert. That the orders challenges.
Your owner,
Yes, ma'am.
no insurance.
There is insurance. Not kindly page number 51.
So you are placed ex parte.
Yes. Because of wrong address. My address is
Now liability is on whom?
by me.
Why? You don't have insurance.
No deal. The contention of the claimant is here.
You are the
There is
offending,
insurance.
you are offending vehicle.
Yes. Page number 51.
Who's the claimant? R2. Respondent number 2.
Yes.
No,
My lord,
Who is the company?
my lord, I am seeking the adjournment for 4 weeks in item number 68 because the main counsel is in another court.
4 weeks.
4 weeks, my lord, or what you 2 weeks, my lord.
Take 4 months. Huh? 4 weeks.
Least
Right.
next week, my lord.
ಮುಂದಿನ ವಾರ ಹಾಕೋಣ. Council ಇಲ್ಲ serious.
Last time also.
All right, last chance will be given to you. You have to argue the matter next week, Mr.
I oblige, my lord.
Ravi Shankar R2, madam, you are appearing?
Yes, madam. Please, madam.
New Year gate.
Insurance company, madam. Respondent number 2.
So there's no liability on you.
Please, madam. It was a violation of the terms and condition of that. There is no DL. The insured himself was driving. He is the owner cum rider. He did not possess valid and effective driving license. That was the evidence let in by the insurance company.
Then the counsel for both all the parties are present before the court. Counsel for respondent number 1 seeks time. Deal is next week. ಏನ್ ಇಂಟ್ರಿ ಮಾಡಿರ್ತೀವಿ ಸ್ಟೇ ಆಗಿರ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್.
Hello.
What is the award amount? Claim petition is allowed, Allah?
Access.
What is the award?
Expert.
What is the award amount?
87,000.
Proceedings are stayed, stay.
Yes.
Perpetual stay.
Explain.
Next week.
Number 69, Arapa A.
Given the total occurrence of the accident and the proof that it will not be detected in activity. So in spite of telling the information to police, so the police have listened to information from the applicant, they have not and made any inquiry to a petitioner or anybody. The only on that from accident.
ಯಾರು ಸರ್ವಾಗಿದ್ದು
R3, next page. R3, insurance company.
ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ. You are claimant, sir. Are you claimant? So your what has happened to the claim petition?
Dismissed. Doubted about the accident.
Occurrence of the accident.
No other than everything.
Your counterpart is not here, Mr. Krishnasammy.
Wrong rate, my lords. My instance is wrong rate. And the 10.30A.M case is registered against respondent number 1 also. And also intimation is received by the police. In spite of that, they have not inquired about the petitioner or anything. Regarding that only, criminal suspected.
We'll have it next week.
Nine magic.
ಇಲ್ಲ ಇವ್ರು ಬರ್ಬೇಕಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಾಯರ್ ಬರ್ಬೇಕು. Have to hear if there is any proper case made out by you, then you call for remand. Otherwise, Learned counsel for appellant is present. Representation on behalf of R3. Release next week.
Number 70 to 72 Arjun, 73. Kalpana PV. 73, Kalpana PV.
Kalpana PV. Was called at 2:57 P.M. There's no representation on behalf of appellant or the respondent number 1 and 2. Release this matter next week.
76, Santosh Gopi.
Then matladaಗಿದೆ. It is yet to be heard ಆಗಿದೆ. ಸಂತೋಷ್ ಎಸ್ ಗೋಗಿ ಶೇಷಗಿರಿ ರಾವ್ ಕೂತಿದ್ರಲ್ಲ ಬಂದಿದ್ರಲ್ಲ ಅವಾಗ್ಲೂ
ಬೆಳಗ್ಗೆ
ಬಸವ
77 Arjun, 78 Kitchen Basvaraj.
ಚೆನ್ ಬಸವರಾಜು next
9, Leader Kitchen.
your second respondent. Janardhan Reddy. Your name is Janardhan Reddy.
Yes, yes.
Fine. 2016 matter.
Yes. They were not.
You are ready. You also want short accommodation. So specific performance suit. Who are you? Before the trial court? Plaintiff.
What are the subsequent purchase?
So what happened to the suit?
It is dismissed.
Huh?
It is
Dis-
not registered.
Dismissed.
Yes, report number 1 should be registered for others.
You are R2. So you purchased from R1. So you had an agreement with R1. Agreement of sale is with R1. So during pendency of the suit, R1 sells to R1.
There was no suit pending.
Huh.
Prior to which you are.
Prior to the suit you have purchased.
Prior to which.
After that, they have filed.
After that,
So suit is dismissed.
you did nothing else.
I paid 30,000 as advance consideration for 2,22,000 for 1 year. That they received, they did not pay me back.
So concurrent finding of fact. So what is the extent of land?
1 year.
1 acre, agricultural land.
Then
Where located at? Your senior wants to argue.
PSP.
ನೀವೇ ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ. Have it next week. Get ready next week.
One submission, if I may make. I'm at serial number 78. I was waiting. There was some disruption in this streaming. I could not, I am for the respondent. I am sorry.
You will call out your case. Arjun ಆಗಿಲ್ಲ. Arjun ಮಾಡಿಲ್ಲ, Mr. Krishnamurthy.
Please, please.
Arjun ಆಗಿಲ್ಲ. I'll call out your case again because both of you are not here. I'm now taken up case number 79. I'll come back to you.
Please, please. Much obliged.
Markadu. The request of both the learned counsels are present before the court. At request of learned counsel for the appellant, relist next week. Take a date of your choice. Even if your senior doesn't come, you have to argue. So take a suitable date. Huh? 14th.
24th.
All right. 24th.
Serial number 80. Sheshagiri Rao.
Sorry, but previous fact I could not get. This fact of the seek short accommodation.
ಯಾವುದು 80 ಅಲ್ಲ? ನೀವು ರೆಡಿನಾ? ನಿಮ್ಮ ಹೆಸರೇನು? ಶೇಖರ್. ನಿಮ್ಮ ಹೆಸರೇನು? ಶೇಖರ್. ಶೇಖರ್, you are ready?
Divergent finding.
And who are you in the trial court?
I am the plaintiff. Suit for specific performance came to be decreed. And first appellate court has reversed the decree.
On what ground?
Though there is an admission, the court has said that I have not proved the agreement. And exercising discretionary one hand, the court has rejected my claim. However, during the pendency of the appeal, there was no stay. The stay deed was executed in my favor. Thereafter, the defendant or defendant passed away. Now on the present appeal. If my lord, anything, the total sale consideration was agreed for the site that is 30 into 12. It is small area in particular town. The 3 lakhs was the same consideration. The total 2,70,000 was paid
By you?
by us. The remaining was deposited. Some more amount can be, my lord, that is what other day I have also
Offered him.
offered. It has to be Amount sale deed ಆಗೋಗಿರೋದ್ರಿಂದ
Now you will return the amount after how many years?
sale deed ಆಗೋಗಿದೆ.
ಆಗಿದೆಯಾ?
Sale deed execute ಆಗೋಗಿದೆ.
ಇನ್ನೇನಿದೆ ಸರ್?
But the appeal ಅಲ್ಲಿ reverse ಆಯ್ತು. First appeal ಅಲ್ಲಿ. There was no stay. Execution filed, the stay of sale deed was executed while taking possession.
No. After the sale agreement,
Suit decree.
suit is decreed and he has executed the sale deed.
He has not executed. Court has executed. the
Correct,
sale
based on the decree.
deed. Based on the decree.
So, and after the execution of the decree, he has challenged it.
Challenge is prior to that, during the pendency appeal, there was no stay.
No stay because
There
of no
was-
stay.
Please. That is why some more amount can be, the matter can be resolved. That is what. I will also keep.
What is the extent of land?
It is only a 30 to 12 feet side.
That's
Small.
You have collected 75, more than 75%.
He has denied the.
Yeah, after that part payment,
Please.
the remaining amount you have deposited?
Deposited and the sale deed was executed.
No, that is, you have deposited pursuant to the decree, not before.
No, my lord, 2,70,000 was given to him only, the defendant only. Remaining 30 has been deposited and said it was taken.
Right, remaining 30 is after.
After decree only. Readiness and willingness is not issue.
But you find out from your client if he's ready, otherwise you
Next
argue.
week, my lord, I will also keep our party present.
Both the learned counsels are present before the court. Counsel for the respondent seeks time. We'll take a date and get ready on that date. Either you agree for the compromise or you go on with the matter.
Please.
Which date you want? 17th, 18th, 17th, released on 17th January.
76, my lord, I am the respondent.
Ah.
I am the respondent.
This has to begin afresh or it is already argued?
The fresh matter.
Are you ready? Are you ready?
Short term is.
Where is Santosh Gogi?
I told the TN council will argue.
Declaration and injunction.
It is declaration on the basis of the will. There are two wills,
Concurrent or divergent?
concurrent dismissal
You are
and the defendant.
plaintiff's appeal.
Please.
There is no representation. The matter is called out for the third time, second time, 3:07 p.m. Counsel for respondent 1 and 2 is present. Relist next week.
Please.
Serial number 66.
Use Baswaraj and Krishna. Or H.N. Baswaraj.
HL Basava.
I am for the respondent in that case, madam.
This
78 ದಲ್ಲಿ I am for the respondent, madam.
also is fresh matter. Synopsis, list of citations filed by advocates for respondent.
ಹೌದು, I have filed, it's a suit for injunction. I am the plaintiff. In both the courts below, suit for injunction has been decreed. Concurrent finding.
Defendant is in the appeal.
Appellant, defendant's LR is the appellant.
And it is a bare injunction, is it?
Injunction declaration ಹಾಕಿತ್ತು. Alternative prayer was that for declaration. The court, both the courts below found that I have made out that I am in possession of the property. The property purchased by me in 1995. That's why the court said the declaration is not necessary since you have made out that you have been in possession of the entire extent of land in the survey number in question. Permanent injunction decree has been passed by the trial court, that is confirmed by the lower appellate court. That is challenged by the LR of the defendant. I have filed my detailed synopsis and so also citations before this honorable court. which contains all the relevant facts, supported by documents.
What was your prayer before the trial court?
The suit was for declaration and injunction.
So both are decreed in your favor or partly?
Both are decreed. The trial court decreed both declaration and granted declaration and granted injunction. The lower appellate court said declaration is not necessary because you have proved that you are in possession of the property. So permanent injunction decree is confirmed.
Declaration relief you have sought, you have been granted.
How?
Along with permanent injunction. There is a question of the first appellate court saying that declaration is not required because you have proved possession.
I kindly see the appellate court decree. Next week, next week it can be disposed of. Concurrent findings so far as possession is concerned.
No, possession is fine, sir. Which is the first relief you sought for? Where is your plaint?
Yes, my plaint is at page 1 of the paper book. Page 1.
Paper book, yeah. For declaration and permanent injunction.
How? At page 8 is the prayer. It's a simple suit for injunction. There was no declaration prayed for. Injunction suit based on title. Paper book page 8 prayer is page 8. Alternative prayer possession, since he claimed that he is 11 ಗುಂಟೆ ಅಂತಾರೆ 1 ಎಕರೆ 31 ಗುಂಟೆಯಲ್ಲಿ ಇನ್ನೊಂದು ಕಡೆ 12 ಗುಂಟೆ ಅಂತಾರೆ. So alternative prayer for possession was made. The lower appellate court said that alternative prayer for possession is not necessary because you have proved that you have been in possession of this entire extent purchased by you. So suit for permanent injunction is confirmed. Prayer is the plaintiff prays that this honorable court may be pleased to pass judgment and decree against the defendant, restraining the defendant, his agents, men, and sons permanently from encroaching upon and interfering with the peaceful possession and enjoyment of the suit scheduled property, and further restraining the defendant from cutting the eucalyptus trees grown on the suit scheduled property belonging to the plaintiff, and grant such other relief or reliefs as this honorable court may deem fit, etc. That was an alternative prayer seeking for possession if the court comes to the conclusion.
Tell me the alternate prayer.
Other ಕೆಳಗಡೆನೇ ಇದೆ. Other ಕೆಳಗಡೆನೇ ಇದೆ. Or in the alternative, in case this honorable, your lordship got it wrong.
Yes, yes.
Yes, this honorable court comes to the conclusion that the defendant is in possession of 12 guntas out of 1 acre 31 guntas of land purchased by the plaintiff. Wide registered sale deed dated 18/5/95. This honorable court may be pleased to declare that the alternative declaration of plaintiff is the absolute owner of the entire extent of 1 acre 31 guntas of land in survey number 8/1. That is the suit scheduled property, and declaring that the plaintiff is entitled for possession of the 12 guntas of land claimed to be possessed by the first defendant. Consequently, direct the defendant to put the so and so and so. Both the courts will have held that the plaintiff has been in possession of this 1 acre 31 guntas of land purchased by me as per the sale date of dated 18/5/1995. Concurrent finding.
So whether the trial court gave an order of declaration that you are the owner of 1 acre 31 guntas?
Yeah, that kindly see the decree. I'll read. Nam synopsis alladella collect madene. The decree passed by the trial court is at I am finding it from the paper book. Yes, page 32 to 46. Page 32 ದಲ್ಲಿ judgment starts. 32. Ajne. Ajne, the decree is order is at page 44. Madam. Dave, your lordship got it, madam?
Yes.
ದಾವೆಯನ್ನು ಡಿಕ್ರಿ ಮಾಡಲಾಗಿದೆ. ವಾದಿಯು ಯಾವ ಆಸ್ತಿ ಸರ್ವೆ ನಂಬರ್ 8/1 ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 31 ಗುಂಟೆಯ ಮಾಲೀಕಳ ಎಂದು ಘೋಷಿಸಲಾಗಿದೆ. ವಾದಿಯ ಆಸ್ತಿ ಸರ್ವೆ ನಂಬರ್ 8/1 ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 31 ಗುಂಟೆಗೆ ಹಸ್ತಕ್ಷೇಪವನ್ನುಂಟು ಮಾಡಬಾರದೆಂದು ಶಾಶ್ವತ ನಿರ್ಬಂಧ ಮೂಲಕ ನಿರ್ಬಂಧಿಸಲಾಗಿದೆ. And the decree passed in RA. ಅದು from 51 to 62. 51 to the appellate court has detailed discuss ಮಾಡಿ that order is passed. 51 to 62. 51 to 62.
Really ಶುರು ಆಗ್ತಾ ಇದೆ. Judgment starts only at 62.
62. Yes, yes. Yes. ಅಲ್ಲಿ order 106 ಅಲ್ಲಿ 106. IA, there was an IA filed by the appellant in that RA that was dismissed thereafter. Appeal filed by the appellant is partly allowed. Judgment and decree passed by the trial court, invoice number so and so is modified as follows. Suit of the plaintiff is decreed. Permanent injunction is granted in favor of the plaintiff, restraining the defendant from interfering with the plaintiff's peaceful possession and enjoyment of the suit scheduled property and from cutting eucalyptus trees grown on the suit scheduled property. Party is directed to bear their own cost. Alternative prayer, it is unnecessary because the plaintiff has proved that she is in possession of the property. Though even 1950 in the title deed I have produced.
Sir, please understand. The first appellate court has not dismissed the appeal of the defendant. It is partly
Yes.
allowed, and
Yes.
does not give you the relief of declaration of title, which was granted.
Alternative prayer ಮಾಡಿತ್ತು. Alternative prayer.
All right, if you are
Since I have been in possession of the property.
You are happy with this judgment?
Yes, madam. Please. Because I am in possession of the property, I have got the title deed. ಅದು alternative ಆಗಿ plead ಮಾಡಿತ್ತು. Because I am in possession of the property.
All right.
Right from 1995 ಇಂದ. Originally suit was not for declaration. Alternative prayer ಆಗಿ ಮಾಡಿತ್ತು ಅಷ್ಟೇ. The documents in the synopsis which I filed on 20th of June 23, all these details are given.
All right, let your friend come. He's not here.
Please. Next week ಅವರು ಬಂದಿಲ್ಲ ಅಂತ ಕಾಣ್ತೇನೆ. ನನಗೆ ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಅಟೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕಿದೆ. Next week if the matter can be had. ಅವರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡಿಸ್ಪೋಸ್. I have filed the synopsis on 26/23. I have given all the details and so also the citations.
1 minute.
Please.
Have you seen the substantial question of law framed by this court?
I think I have noted. Yeah, that I think it is relating to limitation.
Both parties are directed to maintain status quo.
ಹೌದು
ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರೇನೋ?
ಹೌದು, absolutely no problem, because 95 sale deed, previous sale deed I have produced, and 1950 sale deed, I mean gift deed, they have produced. They have admitted, the defendant has admitted everything. Defendant has admitted everything in his evidence. That is called out in my synopsis filed on 20th of June 23. Adanu nodbitre it is very clear. In his evidence, the defendant has virtually admitted the suit claim, admitted the whole thing.
The other side.
In my
representation on behalf of the appellant, the matter is called out at 3:21 p.m. The counsel for respondent is present. Relist next week. Mundarvara.
Please. ಅದು ನನ್ನ ಸಿನಾಪ್ಸಿಸ್ ದಲ್ಲಿ I have noted the whole dates and events and all the points, and so all the citations have been filed. She is a lady of 78 years ಆಗಿರ್ಬೇಕು.
Do you have a copy of the substantial question of law framed by this court?
I will check, Madam. I will check.
First check that and then prepare synopsis.
Please.
66. Rajshekar and Lingaraj. Yes. You are ready, Mr. Lingaraj? Quantum ಮಾತ್ರ ಇದೆ. ನಿಮ್ಮ ಕಡೆಯಿಂದ ಏನು appeal ಇಲ್ಲ. Can be disposed of. It can be disposed of. Yes.
For the minor and then the date of the accident. About the real rate.
17.5 years.
He was hospitalized for 38 days. Surgery was done. And PW2 doctor has assessed the disability to the extent of 85%.
Inpatient for 38 days.
Please. And that PW2 doctor was assessed disability to the extent of 85%. But the tribunal has taken only 80%.
80%.
Yes. And
permanent disability. Permanent disability.
Amputation.
The left leg above the knee.
Above.
Doctor is PW2.
Yes, please.
Where is this? Which para in the judgment?
In para number 15. Para number 15.
That is natural guardian. PW2 17.
16 also.
17. All right, you read 16.
Yes. The petitioner in support of evidence of natural burden has examined the orthopedic surgeon and treated the doctor as PW2, who hired his affidavit as his chief examination, in which has stated that the petitioner has met with an accident said to have been taken place on 22/5/2016 and sustained the following injuries. So, fracture of mid shaft of left femur, fracture of shaft of both bones of the right leg, vascular injury of the right leg. So the petitioner has undergone surgery and amputation of his left leg. After discharge, he was regularly took the follow-up treatment, and recently he has examined the petitioner and found the following difficulty. Difficulty in walking, unable to stand on left leg, difficulty in lifting heavy weight, walking on slopes, climbing stairs, squatting, sitting cross legs, unable to take part in sports activities, and his day-to-day activity and dependent on crutches for walking. So the petitioner has sustained permanent disability to an extent of 85%. The PW2 in his cross-examination has admitted, as on the date of the early accident, the petitioner was aged about 17 years, and as per the case sheet, his age has been shown as 15 years, and it was written as per the information which given by the parents or his relatives, and he has also admitted the petitioner age has been shown as 16 years in the exhibit P19. And he has also admitted as per exhibit P14, the petitioner age has been shown as 15 years. And he has also admitted as per the medical record, the petitioner is not there at the age of 15 years. And he has also admitted that Central Gazette Notification.
Yes.
For the year 2009, and he has denied the petitioner has sustained the physical permanent impairment is only to an extent of 30%. We did not sustain the permanent impairment. He has also admitted the disability which he has stated in respect of lower than paragraph 17. The PW2 being the orthopedic surgeon and the treated doctor in his evidence has clearly stated about the injury which is sustained by the petitioner, as well as amputation of his left leg above the knee due to the accidental injury. And he has also stated about the complaints and the difficulties due to amputation and the treatment taken by the petitioner as inpatient and outpatient. So the evidence of PW2 corroborate the evidence of PW2. Exhibit P6 is the to the city hospital down here, in which it is clear the petition has sustained the following injury. Rushy injuries present over the left side, exposing muscles of the antral compartment. Then the right leg, both bones fractured. Left leg amputation, both legs fractured. The above injuries are previous in nature. Exhibit P8 is the discharge summary which issued by the IMS hospital in Ramyana, in which it is clear that the petitioner soon after the accident got admitted to the hospital and took treatment as inpatient from 22/5/2016 to 28/6/2016, almost for a period of 38 days, as he has sustained the following injuries. Fracture of mid shaft of left femur, fracture of mid shaft of both bones of right leg. So the petitioner has undergone surgery for the amputation of left leg above the knee. Exhibit P9 is also clear, and the petitioner has also took the treatment as outpatient after the discharge. Exhibit P10 to P17 are clear that the petitioner has took the treatment in connection with the injury sustained in a road traffic accident, and he was underwent surgery and left leg has been imputed above the knee. Exhibit P15 on the X-ray reflects the petitioner sustained fracture on both bones of right leg and his left leg was amputation above the knee. So the considering the oral and documentary on record to be just necessary to offer just compensation for following heads. If you pay the suffering, an amount that which is 80,000 was what which is very low. Absolutely, ready to pay the key. Tabular columns.
In page?
In page 38. When you use the 30th. More than. Very tabular column.
Pain and suffering.
Nearly 18,000 was because he was inpatient for 38 days and the surgery, he has undergone surgery and also needed an amputation. Right leg here, both fracture, both fractures. Left leg amputated above the knee. Because of this, it has to be enhanced.
What was that boy doing?
Which kid? School record. Doctor says sports activity can participate. Either as it came about, going to all the disciplines, the watch is close to the tabular column. It requires enhancement on the head of pain and suffering. And medical bills can be kept intact.
That's on actuals.
Calculate what over here.
ಅದು ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್
Yes.
ನೀವು ಕೊಟ್ಟಿದ್ದಾರೆ
Yes, okay.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್
Half of income being for the parents, 97,000 rupiah. For 30 days of money, 9,000 for the parents income. Good deal rupiah. Parents. Loss of income during the future disability as per Master Malik 5 lakh. Again, these figures when amenities, they are overlapped. 50,000. But they are not quite. And today additional charges may require enhancement, also future medical. Future has to be enhanced.
ಇವಾಗ ವಾಟ್ ಇಸ್ ದ ಡಿಸಬಿಲಿಟಿ?
Doctor says 85.
What is the law when there is a disability of 85%? Huh?
It has to be taken as
As?
because 10%. Because unfortunately, and
Photo ಇದೆಯಾ? Photo ಇದೆಯಾ?
photo is also exhibit. It is not.
Master Mallikarjun's case applies for which age and below? What this boy was studying, which class was he in?
So it's not going from the letters.
However it may be, even if he's uneducated, even if he's a coolie, if you see above the knee, his left leg is amputated. Right leg also there is some disfigurement. Then future prospects will have to be given. When there is a disability, permanent disability, 100%, 80% male disability, then it is as good as a death case and it has to be treated as a case of death, and then future prospects will have to be awarded is what I remember reading a judgment, which he has not argued yet. No, you wanted to argue, I think.
Actually, even if it is 85%, 100%, 10%.
Future prospects kodbeka?
Yes.
Which is that judge? Minor illa.
Minor, so I what I was went to the like just now. I thought court can take it for parents. I think 80 is given. Considering the nature of the news, another 40,000 can be granted.
No, the tribunal has decided this case on the basis of Mallikarjun, Master Mallikarjun. So let us see that Master Mallikarjun whether is applicable to this case. Where is that Mallikarjun's judgment?
10% to take up to 30,000. 30% disability, 10,000. Then that has been referred to.
That slab is there. Slab.
It has been referred to.
10 to 30%.
Yes.
Some slab.
Assessment of compensation in case of children suffering disability. Expert observed appropriate compensation on all other rates in addition to the actual expenditure
treatment attendance should be, if the disability is above 10% and up to 30%, over 43 lakhs, up to 50% 4 lakhs, up to 90% 5 lakhs, and about 90% it should be 6 lakhs. For permanent disability, up to 10% it should be 1 lakh, unless there are exceptions to take a different. All right, apart from that, you get management expenses. In the end, loss of future disfigurement and amenities. My submission almost overlap. Both taken as 50-50 could be 1 lakh. That can be kept intact. No, what about his, Mr. Lingaraj, what about his marriage prospects? That loss of disfigurement would include that. Which is the judgment which covers all this? There is one judgment. Which is that? Mallikarjun doesn't cover. This doesn't cover. Mallikarjun case was really basically. There is one more. Which is that? Divya, Deepa, or some other case. Which deals with loss of marriage prospects, future the artificial leg to be put. Syed Sadiq, Mohammed Sadiq case. Anwar, Mohammed Sadiq Allah. Anwar. Syed Anwar or Mohammed Anwar? Anwar's case. Because now his life is ruined now. That's right. I am not that point. I'm only on. That's why whether it calls for deciding on the basis of a death case by awarding future prospects, or the other aspects will have to be compensated, like future marriage prospects, the future expenditures, then the artificial leg that will have to be used by him. Mallikarjun case is there. You should come prepared, mister. In these cases, you are going to render justice to that poor boy. What time? Then you don't argue when you don't have judgment. Don't do half work. Lease. It's grossly insufficient, Mr. Lingaraj.
Yeah,
Correct. So I think he also has not read the judgments. You have to read the judgments in the case of Kajal, Master Ayush, Anis.
Master Karnataka, but Asset was a case where it's about the vegetarian.
Correct. So in that case also, if not for the vegetative states compensation, some compensation will have to be reasonably awarded to this child for loss of that, because now he cannot do his normal life work.
Whatever we approach what you conscious. We are because of the absence of any income take the notion apart and loss of the other rates, non-pecuniary rates can be restricted only one word.
Padimatu, Master Mallikarjun, what is generally? Master Mallikarjun, no, minor, but whether that is a disability is permanent to an extent of?
No, they speak about the government disability, 10%. They are
Slab.
As they are fixed. Up to 90% by actually, about 90% to 6 lakh. That's what they.
ಅಷ್ಟೇ ಮಾಡಿರೋದು.
That's it. They did not work out because they say in case of minors it's very difficult to get the income, their earning potential.
As of the year 2014.
You order the Supreme Court.
ಅದ್ರಲ್ಲಿ ಬರೀ 18% whole body. Correct. But see, there is no amputation. But that again, Supreme Court, though must have stated in Master Mallikarjun slab wise, but it will not fit into this case. ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ that particular case did not deal with amputation or even any loss of any small portion of the leg, even a toe for that matter. ಅದು ಅದರಲ್ಲಿ ಬರೀ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಫ್ರಾಕ್ಚರ್ ಆಗಿತ್ತು. Deformity. Movement restrictions and shortening, limitation of knee movements, muscle cover right knee, limitation ankle movement. So there is no question of amputation. Whereas in the other cases, there is 100% because one is paraplegia, one is a vegetative state. This may not be vegetative state, this is not paraplegia also. So what could be done, either there could be future prospects to be added or increase the compensation under the head of marriage prospects, future medical treatment.
That's what I think about this.
That is why these judgments will have to be looked into for that purpose. Because in Master Ayush, what the Supreme Court has done is, in Ayush's case, 5-year-old, he has become paraplegia.
That was a master 5-year-old. I remember.
It is paraplegia.
Yes, of
In
course.
Anis's case, he is 19-year-old. He has again permanent disability. Hit by a jeep, which what is it, a rash in material. Bedridden, is in coma. He is in vegetative state. So vegetative state again ಮಾಡಿದ್ದಾರೆ Supreme Court. They have considered, it's a very good judgment. You should read it if you have not read. This is 2018-13 Supreme Court cases 119. In that they have put in para 6LE 1, 2, 3, 4, 5, 6 scenarios how compensation has to be awarded. So in that, they have awarded future treatment 5 lakhs. Then they have also awarded loss of amenities for enjoyment of life 5 lakhs. Here nobody is going to marry him, young man. So if these three are awarded, then
Unfortunately, in this case, the doctor is not in specific. Need people have stated about the future techniques. But notwithstanding that, considering the fractions and functional case, that since we may require for expenses for artificial and future expenses may arise, that amount can be considered. Instead of going to all the necessities of all this, we can rework the compensation.
loss of disfigurement 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Can you monetarily compensate a disfigurement of an amputation of leg? It is impossible. We cannot contemplate walking with one leg.
Yes.
The trauma that person has to undergo is unimaginable.
Normally, may I say this the compensation under the loss of disfigurement the made more if it is on a part which is to be exposed like facial regional or upper leg. So it is a case of amputation of the lower leg, which can be covered to some extent. I am not belittling the.
Yes.
So that would come under the head of loss of amenities.
So ಇದರಲ್ಲಿ loss of amenities
ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೋದು
50,000
ಎಲ್ಲ ಸೇರಿಸ್ಬಿಟ್ಟು
ಇದರಲ್ಲೂ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇ
Loss of amenities, pain and suffering is again. It becomes so difficult to award compensation in pain and suffering. Because Supreme Court in the case of Master Ayush awards 10 lakhs from only on pain and suffering.
totally was there. In this case,
And loss of amenities.
fortunately for the layman, the lower layman is affected, not belittling the minister. He can take up some other allocation where the movement of the lower layman will not be required. So, active.
So the boy was studying in which class?
With R2, school record. ನಮ್ಮ ಮಗನ ಮಹಾನಗರಿ ಸರ್ಕಾರಿ ಉರ್ದು ಶಾಲೆಗೆ ಓದಿಸಿದ್ದು ಈಗ ನಾನು ನೋಡುತ್ತೆ ವರ್ಗಾವಣೆ ನನ್ನ ಮಗ ಹಾಜರುಪಡಿಸಿ ವರ್ಗಾವಣೆ ಪತ್ರ ಸರಿ
He's 17 years, he must have finished his 12th. Huh?
We are waiting. Roman 5.
Transfer certificate.
ಅದೇ ಸರ್ ಇರೋದು exhibit
Huh?
exhibit R2.
You're reading R2?
R2.
Huh.
No. What the observation made by the investigation. ನನ್ನ ಮಗನ ಮಹಾನಗರಿ ಸರ್ಕಾರಿ ಉರ್ದು ಶಾಲೆಗೆ ಓದಿಸಿದ್ದು ಈಗ ನಾನು ನೋಡುತ್ತಿರುವ ವರ್ಗಾವಣೆ ಪತ್ರ ನನ್ನ ಮಗ ಹಾಜರುಪಡಿಸಿರುವ ವರ್ಗಾವಣೆ ಪತ್ರ ಅಂತ ಸರಿ ಸಾಕ್ಷಿದಾರರು ನೋಡಿ ಗುರುತಿಸಿದ್ದಾರೆ ಶಾಲೆ 6 ಗುರುತಿಸಲಾಗಿದೆ.
You don't know, you are appearing for the claimant, you should tell me. Which class was he, where is he, what is his family background? Yeah, last ಓದಿದ್ದು ಯಾವಾಗ ಎಲ್ಲಿ which class ಅಲ್ಲಿ? Yes, you have anything in mind, how much should be awarded for loss of amenities, enjoyment of life? We'll rework it.
Yes.
Medical bills as it is, that will remains. Pain and suffering will have to be modified. Before that, loss of amenities and enjoyment of life as per the judgment of the Supreme Court, 5 lakhs can be awarded.
My submission would be what was working in 9 lakh would be about 2 lakhs, because in that case, it is a total paraplegic and he had to be the victim was entirely dependent on. In this case, again, I'm not PDP.
Yes.
But fortunately, for this boy is made up of 15 years and is lower than
All right. What about pain and suffering?
But 80,000 is granted, also can be as 1.1, that's sufficient.
All right. Then, loss of marriage.
That is process 1 lakh.
ಎಲ್ಲ lower side ಅಲ್ಲಿ ಇದೆ.
Yeah.
Ah. All right. But, what about future medical expense for purchase of artificial leg or the huh?
15,000 rupees was
Correct. We are now reworking.
from that. Because the
Artificial leg purchase model.
limber purchase of the prices recently has come down, but that has to be changed for 5 years. That all depends. Sometimes they need not be changed, sometimes. So, because in this case, there is no much medical evidence to that effect.
No, he has lost his leg above the knee. Indian medical.
That's what I told, not the point at all. Taking it all.
He has to buy to live a normal life. If you are going to facilitate him with a artificial limb, he has to buy that artificial leg. Or some. So whether you will get it in 1 lakh or 1.5 is what. All right. That's all. We'll rework it instead of future prospects and all that. But good. Interest is directly, but you are not future, the next government can get. Get the, is the serial number
66.
66 ಅಲ್ಲ? The accident occurred on 22/5/2016. The minor boy was aged 17 and a half years as on date of occurrence of accident. It is stated by the claimant that he was working as a coolie and earning a sum of rupees 15,000 prior to the date of accident. No documentary proof has been produced. Admittedly, due to the occurrence of the accident, the claimant has lost his leg and got his leg amputated above the knee, left leg amputated above the knee. There is a fracture of shaft bones of right leg, both bones of right leg. PW2 doctor who has adduced evidence has opined permanent disability to an extent of 85%. He was inpatient for 38 days from 22/5/16 to 28/6/16. Tribunal, on the basis of the judgment in the case of Master Mallikarjun, awarded compensation for loss of income due to disability at 5 lakh rupees. And awarded under other heads compensation to the claimant. Admittedly, in the present case, the claimant has lost his left leg above the knee. as per exhibit P9. Photograph is what? Which is that exhibit of photograph? P 17. And the photograph is produced at exhibit P17, which clearly shows the amputation of the left leg above the knee. And fracture of the mid shaft of both bones of the right leg. The medical bills have been produced, and on the basis of actual bills, tribunal is awarded 1,43,965, which is retained without any interference or enhancement. Towards a loss of future earning capacity due to the disability, this court is of the opinion that the sum of rupees 5 lakhs awarded by the tribunal retain it.
Yes.
And other heads will grant is retained. Considering the facts and circumstances of the present case, the compensation will have to be reworked, looking into the condition of the injury sustained, the amputation of the left leg, the fracture of mid shaft of both bones of the right leg, future earning capacity, the loss of marriage, future expenses for meeting the requirement of artificial leg, and also the pain and suffering suffered by the claimant. Having heard about the there are tonsils. Towards loss of amenities and enjoyment of life. A young boy of age 17.5 years whose life is now ruined, this court deems it appropriate to award sum of rupees 3 lakhs towards pain and suffering. Just before that, there was loss of amenities, 3 lakhs ideyalla, as against rupees 50,000 and another 50,000 towards loss of disfigurement awarded by the tribunal. Towards pain and suffering, tribunal is awarded 80,000. Considering the facts and circumstances of the present case, 2 lakhs is awarded on this head. Towards loss of income to the parents during the later period during the treatment and later period. Tribunal is awarded 27,000. This court deems it appropriate to award 50,000 under this head. The young boy has lost his future and it is very difficult for any lady to get married to him, considering his physical condition and financial position. Therefore, loss of marriages is to be awarded at rupees 2 lakhs. Towards future medical expenses, tribunal is awarded 15,000. This court would have to consider the provision for purchase of artificial leg in future and further treatment, if any, to be meted out by the claimant. They deem it appropriate to award 1,50,000 under this head. Loss of amenities, Aita. 3 lakhs. Pain and suffering.
2 lakhs.
Loss of marriage.
Okay, 4 lakhs. 50,000. Loss of
50,000
income.
is
During later period.
later period.
50,000. ಆಮೇಲೆ ಮ್ಯಾರೇಜ್ 2 lakhs. ಆಮೇಲೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 1,50,000.
50,000. And
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್
medical expenses.
ರಿಟೈನ್
Huh?
ರಿಟೈನ್ ಆಗಿದೆ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಎಕ್ಸ್ಟ್ರಾ ಎಷ್ಟು
Medical bills retain ಆಗಿದೆ.
ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ 5
ಎಷ್ಟೆಷ್ಟು?
15 lakhs 3,965.
Yes.
3,000.
In view of the discussions about the past following order. We entitled also as per the table mentioned here and below. Accordingly, I pass the following order. Appeal is allowed in part. Claimant is entitled to total compensation of so and so as against 8,65,965 with interest at the rate of 8% per annum. For the enhanced compensation amount. Insurance company shall pay interest at the rate of 6% per annum till the date of realization. Literally some amount to be kept in FD. Just your total amount is for the
15 lakhs 3,965.
out of the entire amount. 5 lakhs shall be kept in a fixed deposit in the name of the claimant in a nationalized bank for a period of 3 years and thereafter extended. You have not deposited any amount. Huh? Deposited? Whether they have withdrawn that release 2 lakhs in favor of the natural guardian? Agidya? Yes. Out of 15 lakhs, estimate is 5 lakhs.
5 lakhs.
10 lakhs he will get for his own use. 5 lakhs you deposit in the nationalized banks for.
It would be interest of the wife.
10 lakhs you can use it for some business or something, some purpose. So that his life can be secured.
Future medical need, yes, but I think a wheelchair.
No. Wheelchair will be much cheaper. Wheelchair will not cost you more than 50,000 to 1 lakh. He has in fact said 1 lakh. I've given him 1.5 lakhs. This is quite reasonable. You should thank your friend, Mr. Lingaraj.
Okay, 100,000 dollars is very store.
ಇದು ಕಂಪ್ಯೂಟೇಷನ್ ಮಾಡೋದು ತುಂಬಾ ಕಷ್ಟ ಇಲ್ಲ.
cases ಅಲ್ಲಿ ಏನಿದೆ?
See what happens. No, in a paraplegia case, coma case, it is easy because it is zero. They can't do anything. So you will need one attendant that can be quantified. In such cases, whether neither you are here nor there, it becomes very difficult.
And it all depends upon facts of each case,
Family background.
Fracture may heal well and he will be, he may get sued because of the now the advancement in the medical field. But in some cases, the same thing, you fall in a toilet and the house can itself be.
Young age alli, if you are having fractures and falls, it will not affect much. It will heal. It will heal easily and you can get over the fracture. Vaisaaದ್ಮೇಲೆ ಕಷ್ಟ ಆಗುತ್ತೆ. I remember myself, I've broken my both hands and both legs, fractured. But when you are young, the bone also grows and it recovers. But as you grow older, it becomes difficult. Thank you, Mr. Lingaraj, for assisting. ನೀವು ಕರ್ಕೊಂಡ್ಬಂದಕ್ಕೆ ಕೇಸ್ ನಿಮ್ದೊಂದು ಮುಗುತ್ತು ಇವತ್ತು. Client will be happy with your performance. You are Rajshekar.
Yes,
ನೀವು ಯಾವ ಕಂಪನಿ ಪ್ಯಾನಲ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
Reliance, HDFC, National.
ಇಫ್ಕೋ ಟೋಕೆಗಿಲ್ಲ.
ಪರ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ IAS ರಿಮೈಂಡ್ ಮಾಡಿ ವಿಷಯ ಹೇಳಿ.
She will call them and we'll tell you. In some of the matters where the insurance companies deposit the amount, and when the claimants file an application for release of the deposited amount, some amount can be deposited unless there is a serious.
Regarding liability or involvement.
So those applications can be listed. I don't think insurance companies.
Deposited amount. Sometimes insurance companies participate in or some opposite interest. So 50% of the deposited amount to be some factor to the victims.
Correct, because timely requirement is important.
And in the application, unfortunately, High Court has later.
I see now we are disposed of. Yours is 2016. No, now also, if we keep the appeal for 4 or 5 years, then by that time he will not even get the benefit of what he requires at that point of time.
Fortunately, even the appeals of 10 and 11 was still actually.
This because Sripad Sastri was mentioning that to list all these applications and it can be disposed of rather than posting the matter for that hearing or IA after 6 months to 1 year.
That can be done.
Just inform.